mentioning part 2, item number 8, my lord. Since there are 2 fixed items today for hearing, my lord, if this matter can be taken up after the vacation, my lord.
You're for the respondent.
Sole
right?
respondent, my lord.
Yes.
I've
who's
taken
for
consent
the-
from the other side.
Okay. Anyone appearing? No.
Yes, my lord.
My lord. Yes,
Okay,
my
you are
lord.
there?
Yan Sang Pui.
It was fixed for today, isn't it?
Yes,
Number
my lord.
8. The matter is between, dispute is between whom?
Siblings, my lord. The
Siblings.
brother and sister. my lord.
Brother and sister. Do you think you can come to some settlement?
We tried before in the Lok Adalat and the matter was referred back, my lord.
Okay, they couldn't
There was no
settle.
settlement.
If it's siblings, most probably property left behind by the parents.
Yes,
it?
my lord.
Anyways, so since both the parties are represented on the submission made by the learned counsels for both the parties, list the matter after the ensuing vacation. Yes.
Much obliged.
Obliged, my lord.
Your Lordship. Your Lordship, with the consent of the other side, Your Lordship, I would like to mention item number 10, Your Lordship.
Part 1 or part 2?
Today's daily list, Your Lordship.
Part 1.
Yes, Your Lordship.
What 10?
Your Lordship, in this matter, Your Lordship, the arguing counsel, Mr. Mustafizur Ahmed, he was supposed to appear today, Your Lordship, but due to some personal difficulties, he is unable. So, matter may be fixed on 7th of the next month, Your Lordship, if possible, Your Lordship.
Okay, 7th next month. Okay. Mention is made on behalf of Mr.
I. H. Lashkar, yes, Lordship, on behalf of Mr. M. Ahmed.
Okay, Mr.
Iqbal Hussain Lashkar.
Iqbal Hussain, learned counsel for the applicant, has prayed for adjournment of the matter by submitting that the arguing counsel, Mr. M. Ahmed, is not able to appear today and has therefore prayed for adjournment. Ms. Vane Isiami, learned additional BP for the state respondents, is present. In view of the above submission, list the matter of on 7/10/2025.
Highness.
Item 1.
You cancel that mention. Okay, just make the name. Yes, 1.
My lord, if I may take your lordship to the previous order, 2/9/2025. Last para, considering the fact that the order of this court was passed on 17/3/2023, and also the fact that the respondents had already taken time on several occasions, the respondents have filed their affidavits within 2 weeks without fail.
Respondents number 134, 7 to 11, is it?
Yes, my lord.
2 and 5 have passed. So, yes,
My lord, affidavit will be filed today, my lord.
we'll be filing the. Okay, good. Mr. Victor El Rate, learned counsel for the petitioner, is present, along with Ms. Deborah Nunzeri, learned counsel, appearing on behalf
of Miss Mary.
Mrs. Mary El Kiante, learned counsel for respondents number 134, 7 to 11. The learned counsel for the respondents submits that they will be filing their counter affidavit within the course of the day. In view of the above submissions, list the matter.
Next week, my lord, Monday,
Okay, list the matter in the next week.
Monday, please.
We'll just make it. Why? What's the urgency?
My lord, the matter pertains to regularization of the Petitioners Association SSA employees. Now, they were also about to conduct indefinite strike all over the state.
So
If the matter may be taken up urgently, my lord.
this is a contempt. So we'll see whether.
My lord, if this
What
matter
I have been
may be-
served advance copy of the affidavit. I have, on the glance of it,
Yes,
there are no steps
what
taken by the
about Mrs.
respondents.
Mary will have to
My
be
lord,
there.
Yes, my lord. She will still be on leave next week. So if this matter may be taken up after a week.
We'll have to make then Mr. Ram Murmur, is it?
Yes.
Learned counsel for
That's one number then 2 and 5.
2 and 5 is present and submits that counter affidavit has already been filed. In view of the above submissions, list the matter after 1 week. Mary has to be there, otherwise we cannot rush. We'll have to wait anyways. Fixing the matter
Date may be fixed, my
on
lord.
Monday, after 1 week on, When is she joining? She's indisposed or what? What's wrong with her?
No, she's in this.
After 1 week on,
26, my lord.
yes.
Today is 18.
On a Friday, list the matter on 26th, end of the next week,
I'm
No,
obliged.
after 1 week, okay, on 26th, before the vacations, yeah.
Item 2.
My lord, on behalf of the state respondents, we will be filing the affidavit in opposition by tomorrow. And if the matter be listed next week, my lord.
Okay. Miss
Daphne Shoitongi on behalf of my senior, Mr. Jesse.
so-and-so, she also appears on behalf of her senior, Mr. J.C. Lalnunsanga, along with Mr. Simon, so-and-so, learned additional AG for the state respondents. The learned additional AG submits that he will be filing the counter affidavit
By tomorrow, my lord.
by tomorrow.
If I may, Your Lordship,
While Miss
I'll be representing
Lady
respondent
so-and-so
number 4.
appearing on behalf of a respondent number 4. What?
Secretary CADC.
So appearing on, so have you filed a counter?
My lord, yes, I have filed.
Submits that they have already filed their counter affidavit. Yes, in view of the work,
Lordship, if the matter may be fixed on the 13th of October.
there's no urgency in the
That'll be
matter.
too long, my lord. There's some urgency. That is why I've made my submission, my lord.
Oh, what is the matter about?
Lordship, this petition was filed for quashing and setting aside the notification declaring governor's rule upon the CADC, my lord.
So what is the present situation right now in CADC concerning this? What is happening? Again, this is regarding security, majority, etc. So what's happening? Because there's always something happening that side, isn't it? Anyways, in view of the above, we'll make it next week. Let's see what happens. Okay. In view of the above, list the matter in the next week, since the learned additional AG has expressed urgency in the matter.
Obliged, my lord.
Item 3.
May it please your lordship, on behalf of the state respondents,
Almost ready. So, have you filed?
your lordship, initially I had given the notice to the petitioners as well. However, your lordship, there were some changes which were made in the last minute, and I was given the instructions for that certain change in my affidavit, your lordship. So if I may be granted at least 3 weeks time, and also there are some ineligible documents which have been annexed, your lordship. So if I have to get a typed copy of the same. So if 3 weeks time may be granted, your lordship.
Mr. Victor L. Rossi, learned counsel for the petitioner, is present along with Ms. Lalun Hui, learned government advocate for the state respondents. The learned government advocate has prayed for further time to file the counter affidavit by submitting that there are certain changes that is required to be made in the draft counter affidavit, which needs further consultation with the concerned department.
My lord, one small submission, my lord. In the affidavit, my lord, let it be made sure that the direction as passed by this court in 22/4/2024, 22/4/2024 be complied with. There's a specific direction made by this court on 22/4/2024.
In view of the above, this is the matter after 3 weeks wherein the learned, wherein the state respondents are to clearly address the directions directions given by this court in its order dated 22/04/2025.
24.
2024. 2024. Oh, it's last year, along to address the directions given by this court in its order dated 22/04/2024 in the affidavit to be so filed.
Much obliged, Your
This
Lordship.
is the matter after
obliged.
3 weeks.
Item 4.
My Lordship, I'm appearing on behalf of my senior Mr. Bila Ramenga, counsel for the petitioners. Indeed, my Lord, if we may kindly be granted further 3 weeks' time to file our
You join the
rejoinder
affidavit.
Yes, my Lord.
Okay. But Mr.
Loma Maralte.
Loma Maralte, learned counsel, appearing on behalf of the senior Mr. B. Yalramena, learned counsel for the petitioners, who has prayed for further time to file the rejoinder affidavit to the counter affidavit filed by the respondents. In view of the above, list the matter after, how long will it take? How much time do you
3
require?
weeks.
After 3 weeks, the presence of Mrs. Linda L. Pambal, learned additional AG, and Ms. Zaram Sampui, learned CGC, is for the respondents is noted. Yes.
Much obliged, madam.
Item 5.
My Lord, this Honorable Court has, by order dated 25th March 2025, already filed the, framed the substantial questions of law. And now my learned friend, the respondent, had filed her affidavit in opposition, rebutting
Lord.
the said proposed substantial questions of law, which otherwise should have been taken up at the time of hearing, as per Section
So
105.
this matter is ready for hearing?
My Lord.
My Lord, I would like to submit that on 25th March 2025, without furnishing me the memo of appeal, the court has formulated the substantial question of law. Because of that, I objected the alleged formulation of substantial question of law. And because of that, on 7/8/2025, this honorable court have permitted me to file written objection. I would like to.
So at the time of hearing of the matter,
My
we
Lord,
consider
I have
that-
received.
Because
yes,
there-
I have received the affidavit
Because-
filed by my learned friend.
Because what they put for substantial question of law is some other question of facts, not question of law. Because of that, I'm
So
objecting.
at the time of hearing,
Yes.
okay, we will consider all that. If it's this thing, it's a question of facts and not substantial a question of law, then that also can be decided at
My
the
Lord.
time of hearing of the RSA. We'll fix it for hearing then.
My
both
Lord.
of you are ready, isn't
My Lord.
it? Because today it's listed for admission, so admitted, we'll list it for hearing.
My Lord.
Then your objection will be considered. Okay, this is not, then it can be disposed of there and then. Yes, heard Mr. Tila Zakima, learned counsel for the appellant, also heard Ms. Jacinta Zothanmoy, learned counsel for the respondents. Having heard the submissions made by the learned counsels for both the parties, wherein a written objection has also been filed by the learned counsel for the respondent regarding the substantial questions of law that has been framed, this court find it appropriate to admit the instant RSA, regular second appeal, okay? Instead of RSA, the full form, regular second appeal, and matter be listed for hearing. Where do you want it?
After the ensuing vacation, my Lord.
After the ensuing vacation.
It is obliged.
Item 6.
Your Lordship, respondent 1, 2, and 3 have filed their affidavit in opposition. We are supposed to file the rejoinder affidavit. For that, we need one specific information, and we are still applying
Okay.
that
Some more
information
time.
through RTI. Yes, please.
Okay. Heard Mr. J. Malsonzola Vansong, learned counsel for the petitioner, who was prayed for further time to file his rejoinder affidavit to the counter affidavit filed by the respondents. In view of the above, list the matter after 3 weeks?
Yes.
After 3 weeks, full stop. Then the presence of Mr. Lom Kima, Lom Omaralte, learned counsel for respondents number
1 and 2.
1 and 2, and Ms. Zairam Sangpui, learned counsel for respondent number
3.
3 is noted. Okay, Zairam Sangpui, learned CGC. Yes.
Obliged.
Item 7. Lordship, this is one of the preferred case to mediation. However, we are not able to settle the matter, Lordship.
Oh, okay. What
And it has
happened?
come back before this court. And Lordship, as per the last court order dated 16/6/2025,
MSCT should be settled. What happened? What is the amount?
That's
What
a-
is this thing? Appeal was regarding what?
so we deny our liability, Lordship.
But in this thing, for settlement, even though you deny,
My lord, ongoing,
should be able
ongoing
to-
through the grounds of appeal, my lord, the quantum was challenged.
Yes.
so it's a quantum.
Quantum,
It's a
basically
So you
quantum.
couldn't settle in regarding the quantum or what?
Lordship,
They-
yes, we
they
tried,
could-
but
They tried but could not settle the matter outside there.
Okay.
And
So
they
have
are
you
yet,
advised the parties, both of them, that you cannot get what you're demanding, but at least somewhere in midway you have to, both of you have to step back a little bit. Anyways,
the appellant was instructed to do paper publication. The same was done and they are yet to file.
Lordship,
affidavit.
yes. As per this honorable court order 16/6/2025, Lordship, I was directed
the
to.
owner.
Yes,
So
owner
you-
and
you're
driver.
trying to
Owner
put
and
the
driver.
blame on
Yes,
the owner and
we
the
have
driver.
already published in the newspaper. Then I have received back the this newspaper.
Okay,
So I
the
may be
affidavit
given.
has yet
Yes,
to be
I have
filed.
to file the
Okay,
affidavit.
yes. Heard Mr. Johnny L. Toto, learned counsel for the petitioner, along with Mr. L. H. Lian Shima, learned senior counsel for the respondent number 1 to 2 / claimants, assisted by Miss Ruth so-and-so. The learned counsels submit that the parties were not able to come to any amicable settlement through mediation. In view of the above, it is seen that notice upon the private respondents number 5 and 6 is not complete till date. The learned counsel for the appellant submits that they have taken steps for service of notice upon respondents number 5 and 6 through newspaper publication and has prayed for time to file the affidavit to that effect. In view of the above, list the matter when in the next week.
Lordship, yes, in 6 to 10. After
Okay.
vacation, Your Lordship,
Okay.
if 6
Vacation
Immediately after
between
the
6
vacation.
yeah, immediately after
Okay.
vacation.
So that
the
will
week
be
commencing
after-
from 6:10, my lord.
6 to 10.
Okay, in view of the above, list the matter on. But if they are coming from Mamet, okay, in newspaper publication, what date was fixed for the appearance?
Lordship, yes. On or before 24/7/2025.
7 July, my lord.
Yes, Lordship.
In view of the above, list the matter on, we'll make it 7th,
7, yes, my lordship. 7:10.
right after the vacation becomes 7/10, 2025.
Oh, nice.
Orders, item 11.
Your lordship, this is an application for
Notice
condon.
complete. Ah,
Yes.
My lord, I'll be appearing on behalf of the respondent number 1.
one. This is the first time you are appearing, is it?
Yes, my lord.
Yes,
How,
so are you going to file any counter? How many days delay?
yes, my lord, I'll be filing an objection within 3 days.
1,883 days. Then-
My lord, copies have not been served to me as yet
Okay.
because the AD card did not reach the respondent.
Okay, Mr. K. Liana, learned counsel for the applicant / appellant is present along with Mr. Rosang Zwalaralte, learned counsel for respondent number 1 and Mr. Samuel so learned counsel for
2 and 3, my lord.
respondents number 2 and 3. Good stuff. The learned counsels for the respondent. What about 2 and 3? Will you be filing anything?
No instruction.
Respondents, will just make it respondents. Have prayed for time to file their written objection. In view of the above, list the matter. After the vacation?
My lord, there's some urgency in this matter because
Okay.
there's an ongoing execution
Yes. So when will you be able to?
within 3 working days, my lord,
Okay, list the matter in the next week.
next week. And copies to be served to me, madam.
Meanwhile, copy of the IA to be duly served to the learned counsels for the respondents. Yes.
My lord, if a fixed date may be fixed,
When do you want it? Next
20
week? Any date?
25th.
On 25th, 9, 2025. Yes.
Thank you, Your lordship.
Is the matter in the next week on 25th.
Item 12.
Yes, may it please your lordship, I am here for the applicant. And my lord, this IA has been filed seeking continuation of a delay of 30 days in filing the connected civil revision petition against the order dated 15/5/2025 passed by the Court of the Learned Civil Judge, Senior Division 1, Lunglei District. Yes,
Will issue notice?
yes, my lord.
Ahat Ms. Rosie Manlongsani, learned counsel for the applicant / appellant who has filed the instant application under Section 5 of the Limitation Act, 1963 for condonation of a delay of 30 days in filing the connected revision petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure against the order dated 15/05/2025 passed by the Court of the Civil Judge within bracket Senior Division -1 close bracket Lunglei Judicial District, Lunglei. in CMA number 25 of 2025 arising out of probate case number 5 of 2025. No. 2025 full stop. Issue notice to the sole respondent, is it?
Yes,
to
my lord.
registered post with AD within 3 working days, returnable by 3 weeks. List after 3
Vacation.
weeks. It will be after vacation anyways, 3
Yes,
weeks,
madam.
isn't it?
Hearing item 13.
May it please your lordship.
Yes, we had heard this somewhere, but then we were required to hear again because now I don't recollect. It is RFA, isn't it?
Yes, RFA 53. By challenging the
So
order.
RFA, okay.
If I may, my lord.
This is also being listed in the
Hearing
part
list.
2 list, isn't it?
Yes.
I thought there were going to be 2 hearings, but it's the same. RFA 53 and listed twice. Wasn't required to be listed in this today's matter. Anyways, so it's actually one matter that we're going to. I thought there were going to be 2 hearings.
My
What is
lord,
the background?
I already
Come back, okay.
submitted the chart regarding the ground of appeal.
Okay, but what is the background? Just give me a brief.
Yes, my lord, if I may permit
Where
it,
is your chart?
I'll
Let me
submit
see.
the background first.
Wait, where's the chart so that will become easier for this court because the file is very, very thick.
Chart for hearing.
Yes, here is your grounds of appeal. This aside for the time being. Then, when did you file the chart?
In the last occasion,
And do you have a spare copy? We'll have to complete today the hearing.
Yes.
Listing it another day, it becomes difficult because other matters are considered in
my lord,
between.
I'll first to
the
introduce the
background,
matter.
the
In the
background.
meantime, I may print it out from my
Yes, yes.
room.
The background.
Yes, the background, my lord. Because some ground of litigation has been there before this RFA, my lord. RFA 53 2023, that is the present RFA, was by filing challenging judgment and order dated 17/3 2023.
Where's that?
Prior to that CS 59 2016, now the present respondent number 1 Saithang Pui Silo filed CS 59 of 2016. In the meantime, WPC 155 2016 was
See, the dispute is concerning some landed property.
Yes,
isn't
my
it?
lord. Yes, my
Located
lord.
where?
yes.
At Bongkon or
Oh,
Zemabok. Now
Zemabok.
I'm recollecting.
Yes.
Somewhere there,
Yes.
there was that dispute, landed property.
Yes, my
Okay.
lord. Yes.
So, the present respondent had filed a civil suit.
Present respondent number 1 Saithang Pui Silo filed civil suit number 59 of 2016. Then, meantime, WPC 155 2016.
No, so what happened to 59
My lord,
2016?
I may, if I may, this was filed by the present respondent number 2,
Which one? Civil
Tanzava.
suit. Civil suit.
Yes, in that petitioner in WPC 115 was the present respondent number 2, Tanzava.
Wait, come again. I'm
The
lost.
both
See,
the
see, wait, let's start from ABC, okay? Respondent number one, he is the owner of some landed property.
Yes, my
okay?
lord.
Now, something happened where he was required to file a civil suit, 59 of 2016, okay? And in the civil suit, who is the respondent? Defendant?
The present private respondent Tanzawa and state government.
Defendant is the present respondent number
Two.
two.
Tanzawa
Okay.
and state
Tanzawa.
respondent, defendant.
Well, respondent number one is Saitangpuya.
Petitioner is Saitangpui.
Ah,
Plaintiff is Saitangpui.
so okay, no,
In CS, no, in
in
CS
the
59.
CS, he
Ah.
will be if it's a civil suit, the plaintiff,
Yes, Saitangpui Silo.
who is now the respondent number one, isn't it?
Yes, my lord.
He's a plaintiff, and he filed a suit against a defendant who is presently the respondent number two.
Yes. Two
Now
and
both
state.
of them are together in one
Yes.
side. Okay.
Even
Then-
in the petition, they are not going together. However, in the middle of the case.
They are both the respondents.
Yes.
Okay, so CS, then what happened to CS 59 slash?
In
whose
CS
favor?
59, we are not a party.
Okay,
Union
you are
of
not a
India is not a
party.
party.
Okay, no.
Then we are not aware of this case. Then after disposal of that civil suit, we
How was
received
it disposed? How was it disposed? In favor of the plaintiff or the defendant?
in favor, both in favor of both. Half of the land has been distributed to them.
Okay, so, okay, land was, okay, fine.
Even though there is no
CS disposed.
any specific order against Union of India. However, in the order at para 15,
Okay.
they
When the
stated that
CS was disposed, the land was divided between both of them, and that's when you are affected.
in the order itself, nothing has been mentioned. However, in the paragraph 15, they
Okay,
stated that
let's see,
the land has not been taken back from the BRTF. Then, after disposal of that suit, there
Para
are
15, you agree with para 15 of the judgment and orders?
Yes, my lord.
Is it?
judgment and order 165,000.
You were mentioned while you were not a party. Okay. What does it say? So, then what, okay, para 15.
That
page?
order was at page 166 of the paper book. Oh, no, that is for different.
No.
My lord, I'm
Of the
sorry.
paper book.
I'm sorry. That's it. At page 247. It started from page number 247, my lord. Then the relevant portion is at page 273. Para 15. Then in the last sentence, in the last line, it is admitted fact that the plaintiff have not taken back possession of the suit land from the BRTF till date. That's much, my lord.
273.
273 from the last line.
Oh, it is an admitted fact that the plaintiffs
It is admitted fact that
have not taken
the
back-
plaintiff has not taken back possession of the suit land from the BRTF till date, and the whole area of the land covered by permit number 191 of 1974 has not been sold to them by the defendant number one. Here, they just mentioned they not taken back from BRTF. Then, after disposal of this, we received letter from the Land Revenue and Settlement
So,
Department.
but this is correct that the plaintiffs have not taken back the land.
My lord, in their petition, they have not say in what manner the BRTF occupied their land. They just stated that not taken back from the
Okay.
BRTF.
While your claim is that it does not belong to the plaintiff. Is that your case?
The case in this case is the dispute between the plaintiff and the Tanzawa the present respondent number 2 only.
Okay, but
Then the
you were
challenging-
mentioned, so the landed property, according to them, is actually occupied by the BRTF.
No stated they stated then not taken back. They just stated they not
So
taken
the
back.
land occupied by the BRTF belongs to the plaintiff, it appears.
Yes,
As
my
per
lord.
this
As per
statement.
the judgment,
Okay.
they distributed the claim land into equal half.
Hmm.
Then after disposal of this case, we received one letter from Land Revenue and Settlement Department. That is at page 583. 583.
583. Wait, let's come to the same page.
This is the letter addressed to the chief engineer BRTF project Puspak. Paper book, second paper book.
Okay, 583. Exhibited as D26. Yes.
Yes, 26. If I may read, my lord, to the chief engineer BRTF project Puspak, subject civil suit number 59 of 2016, Saithang Pui Sailo versus State of Mizoram, reading. Sir, in inviting a reference to the subject cited above, I am directed to inform you that the Senior Civil Judge 1, Aizawl District, in the order dated 5/4/2019, a copy enclosed, had decreed that the order dated 24/4/2015, which declared the permit number 191 of 1974 to be vacant land, is null and void, and it has been set aside in cause. The court revived the permit number 191 of 1974, reissued on 17/11/2003, and however declared the area of the land already settled in favor of the pro forma defendant number 4 and 5, that is Sri Dr. Rin Pluanga Bethlehem and Sri Bialjawa Electric Veng, shall be deducted from the area of 29.48 bigas initially covered by the said permit. Therefore, this department is directed to make necessary correction with regards to permit number 191 of 1974 and to demarcate the same location of Zemabok Aizawl and to bifurcate it into two equal half into the plaintiff number 1, Srimati Saithang Pui Sailo to equal note Aizawl, and the defendant number 1, Sri Tanzawa Saitwal. Therefore, the plaintiff number 1 shall be issued a respective land pass in her name for the site fencing towards Aizawl. It is noticed that BRTF Project Puspak, the occupant of the said suit, has not been included in the case. Accordingly, the additional government advocate Aizawl district has been requested to initiate filing review petition. Therefore, I am directed to request you to take necessary action from your end through your standing counsel immediately. We received this letter. Then, after receiving this letter, they decided to file review petition. In the meantime, they asked the legal opinion of Central Government Council, wherein the Central Government Council give advice not to interfere into, because we are not a party, and in the order there is nothing stated about Union of India. Then, however, the petitioner, the plaintiff as well as the defendant, along with the state surveyor, land revenue and settlement, came into our office trying to bifurcating the land. That is why it is in danger of the for the office. Then they are decided to file RFA as a third party aggrieved. Accordingly, we file RFA 16 of 2020. It was at page 609. That RFA 2020 was allowed by the Honorable High Court and passed an order. My Lord, that order was at page 609. 609.
So operative part is third party appeal.
Yeah. My Lord, if I may started to read from para 5.
Yes.
The landed CCC submits that the appellant, in that we are appellant, are not in possession of any land covered by permit number 191 of 1974. Number 6, the above stand of the appellant vis-a-vis stand taken by the respondent number 1 and 2, plaintiff, before the landed trial court clearly goes to source that disputed question of facts are inexistent. Besides, the disputes between the respondent number 1 and 2 on the one side and respondent number 3 on the other side in civil suit number 59 of 2016. However, the civil suit number 59 of 2016 has been decided without making the appellant party in the case. Number 7, in view of this court, the appellant are necessary party to the suit in as much as the property that is currently in possession of the appellant would be affected by the impugned judgment and order dated 5/4/2019. Para 8, in view of above, the court is of the view that the impugned judgment and order dated 5/4/2019 should be set aside and the case remanded back to the learned trial court for trial de novo, trial, wherein the appellant should be made a party to the suit. Number 9, the learned counsel for the party have fairly submitted that the matter should be remanded back and the appellant should be impleaded in the suit before the learned trial court. Number 10, in view of the finding of the court and also consent given by the parties, the matter is remanded back to the learned trial court, who shall implead the appellant as a party to the suit. 11, accordingly, the parties shall appear before the learned trial court on 24/9/2021. The learned trial court also shall impleaded the appellant as defendant number 6 and 7 in the civil suit and allowed them to submit their written statement within a specific time period. The appellant may also allow to cross-examine the witnesses if the learned trial court decided to retain/rely upon the evidence of the witnesses already recorded by the learned trial court. Number 12, as the matter has been pending for a long time, the issue at hand will regards to the appellant stand being a very specific nature which may require a verification report to be made by the Land Revenue and Settlement Department. The learned trial court shall make an endeavors to dispose of the civil suit as early as possible and preferable within a period of 1 year. Consequently, the impugned judgment and order dated 5/4/2019 passed by learned trial court in civil suit number 59 of 2016 is hereby set aside. The appeal is accordingly allowed. Then this is the history. In the meantime, my lord, the present respondent number 2, Tanzao, also filed WPC 155/2006. Both CS as well as WPC challenge the order passed by Land Revenue and Settlement Department in pursuance to this honorable court order in contempt case 16 of 2016.
No, WPC number what?
Contempt case number 16 of 2015 arising out of WPC 48 2015. That is at page 152, my lord.
No, then the respondent number 2 meanwhile had filed a WPC 40 of 2015. Is it? Which was disposed of?
My lord, they disposed for this court disposed the matter for reply the representation submitted by the plaintiff. However, due to not compliance with the court order within a time, contempt case has been filed.
Okay, how was it disposed of? Just come back.
My lord, that was at page number 152.
552.
That was the order passing writ petition 48 2015.
No. 552 is not the order. What is the order of the court in writ petition number 40 of 2025?
My lord, in pursuance to this order, spot verification has been conducted by the state respondent and issue order. That order has been challenged by both of the present respondent number 1 and 2.
Okay, 500, no, WPC 40 was disposed of by saying that spot verification.
They here for spot verification. However, they also submitted representation to the state or Land Revenue and Settlement Department. This court order permit to
Where's the court's order?
here page number 152, my lord.
152. So before the matter was taken up de novo,
My lord, prior to that, they
Prior to
challenged the
that-
order passed by Land Revenue and Settlement Department in pursuance to this earlier writ petition 48 of 2000.
okay, prior to the matter being taken up as de novo, there was a writ petition already pending
Yeah.
and disposed of as per the order. Where's the order? Page
152. The relevant portion is from page 154.
writ petition 48,
That was filed by Saitang Pui Saido, the present respondent number 1.
number 1. I thought you said respondent number 2. Okay, number 1.
My lord, from the third paragraph, after hearing, that is page 154.
Yes.
After hearing the counsel for the both parties and as agreed by them, this writ petition is disposed of in the motion stage itself with direction that the Principal Secretary, Land Revenue and Settlement Department, Government of Mizoram shall dispose of the said representation of the petitioner dated 27/5/2014 on or before 31st August 2015 with a speaking order subject to condition that the petitioner shall submit the certified copy of this order along with a copy of writ petition and all the annexes appended thereto before the said Principal Secretary, Land Revenue and Settlement Department, Mizoram on or before 8/5/2015. While disposing of the said representation of the petitioner dated 27/5/2014, the authorities shall inquire into the matter, verify the relevant and original records of the Land Revenue and Settlement Department with regards to allotment and settlement of the land that petitioner purchased, giving the parties an opportunity of being heard, including the petitioner and the person whose LSC is going to be cancelled, if decided. After disposal of the said representation, authorities shall intimate the outcomes of the same to the petitioner with the aforesaid observation and direction. This order petition stand disposed of. My lord, this is
Okay,
the
this
order.
was before the civil suit.
Before civil suit, before civil suit.
Okay, so
Then-
first, so you should have come to this. First, there was a writ petition.
Yes, my lord.
Now, this was how the writ petition was
Then,
disposed of. Then after that, the civil suit. Is it?
Yes, accordingly, my lord, accordingly, Land Revenue and Settlement Department issued order relating to this. That is at page 131. The plaintiff challenged this one. 131. Annexure 33. That, my lord, if I may read.
Yes.
Order numbers so and so in compliance with the Honorable High Court order dated 15/5/2015 in connection with contempt case 16/2015 Srimati Saithangpui Sailo versus State of Mizoram arising out of WPC 48 of 2015. The authorities of Land Revenue and Settlement inquire into the matter and verified the relevant and original records of the Land Revenue and Settlement with regards to allotment and settlement of the land that the petitioner Srimati Saithangpui purchased, and the following facts were revealed. Number 1, permit number 682 of 1963 allotted to Pu Liantudaya was later partitioned into 2 parcels of land under permit number 190 of 1974 and permit number 191 of 1974. Number 2, the area under permit number 190 of 1974 was acquired by the BRTF and compensated for. Number 3, permit number 191 of 1974 was converted into periodic pata number 1 of 1977 area 2.0 bigas by Liantudaya, thus superseding permit number 191 of 1974. The location and boundaries remains unchanged. This periodic pata number 1 of 1977 was then sold to F. Bialzawa in the year 1977. Number 4, the periodic pata number 1 of 1977 was again mutated in favor of Pu F. Bialzawa on 25/3/1977,
Same
which,
year? Okay.
which was again settled under LSC number 103 of 1985 in favor of F. Bialzawa. All the above transaction was done before Pu Liantudaya passed away in 21/1986. That is Liantudaya's original owner of permit number 682. Number 5, when Pu Thanzawa, son of Liantudaya, late prayed to Chief Secretary on 6/6/2002 for the demarcation of permit number 191 of 1974 on the plea that he was outstationed at Saitwal. It appears that he has no knowledge that his father Liantudaya had already sold his permit number 191 of 1974 to Pu Bialzawa, YBX in 1977. Number 6, the government, without knowing the full facts, and convey approval for conversion of permit number 191 of 1974 into house site with 2 bigas and later converted the area to 29.48 bigas on 5/11/2003. That is long after permit number 191 of 1974 was already mutated into LSC 103 of 1985 in favor of Pu Bialzawa. Number 7, this was however clarified as under White Letter so and so dated 10/5/2002 with regards to correction of the area of land under permit number 191 of 1974 from 2 bigas to 29.48 bigas. It was decided White Office Memorandum number so and so dated 26/8/91 that henceforth only the area allotted as shown in the original paper be allowed for conversion into permanent settlement, even if the boundary description covered the area. In compliance with the above instruction, claim of the land for which revenue taxes are paid only can considered by the government. In this case also, claim of the compensation in favor of Ubiazawa was considered for which taxes are paid by the landowner. In view of Land Revenue Acts and rules pointed out above, claim of Pu Hanzawa, son of Lian Tudaya late, may be treated as closed chapter, since periodic Pata number 1 of 1977 was mutated in favor of Pu Biazawa. The issue of inclusion area larger than recorded but within the boundary description of the periodic Pata should have been settled at the time of diversion and settlement of periodic Pata into house site LSC. And whatever area of the land might have been lying outside the recorded area but bounded by the described boundary of permit of or periodic Pata was already allotted to BRTF as vacant land. There appeared to be no sufficient ground for claiming any right based on permit number 191 of 1974 at this stage. From the facts stated above, the permit number 191 of 1974 was already converted into periodic Pata number 1 of 1977 in supersession of the periodic Pata number 191 of 1974 and later on mutated into LSC 103 of 1985 with the same location and boundaries. The permit number 191 of 1974 cannot be included and entertained in the present issue. Hence, the claim of the petitioner cannot be sustained. Then there is some binding correction, my lord. 135 is the continue.
135?
Yes. They enclose it again, this two paper. This order hereby revokes government approval for conversion of permit number 191 of 1974, measuring 2 bigas into house pass, white letter dated so and so dated 6/11/2002 as permit number 191 of 1974 was no longer inexistent in 2002. Further, the order of government convey number so and so dated 10/10/2002 cancelling LSC number 103/1 1805 of 2006 belonging to Dilal Runtluangi. Dilal Runtluangi is also hereby revoked and spot verification conducted under the leadership of Director, Land Revenue and Settlement reveals that the LSC falls outside the fencing of BRTF. That is the order passed by Land Revenue and Settlement in pursuance to this Honorable Court order in WPC 48/2015. Then this order was challenged by way of CS 59 of 2016.
Okay, then we come to 59.
Yes.
Isn't it? Yes. This order was challenged in the CS, but you were not made a party.
Yes, my lord. Then later on, we file RFA being a aggrieved third party, and we are allowed to implead it as per the order dated 16/9/2021, passed in RFA 16 of 2020. My lord, now, that is the history of the case.
Okay.
Then now, my lord, I'm
So de
trying.
novo trial was conducted?
Yes, my
in
lord.
CS? Okay.
My lord, then I can come to the chart for hearing. Even though there are so many grounds, however, I will be highlighted the most important for.
So, but in the impugned order, so what you just read is the impugned order, is it? that little part. No, after the de novo trial, what happened to
Yes,
the civil
after the
suit?
novo trial, my lord, uh, we are impleaded. However, the plaintiff, Sai Thang Pui,
So what is the judgment of the civil suit then?
then that was
So this is an appeal against the civil suit.
civil suit, amended
59,
civil suit,
2026
amended
after
civil
the
suit.
de novo, isn't
Yes,
it?
yes, my lord. We challenge now this.
So what is the impugned judgment? Let's have a look at that.
Yes, my lord. The impugned judgment.
Page.
Page 165.
So you participated, but still you were unhappy
Oh,
because of something. So what? Let's see that.
Oh, my lord, I'm sorry. That is. Dito ko tiyo. Pinili sa road.
From the paper book, isn't it? You're looking at the paper book.
$17.5. There ka.
Impugned judgment. Impugned judgment in the paper book. It's dated because then there will be two judgments. So we are
Page number 845. It started from 845.
845.
My lord, even though 18 issues has been framed during the pendency of the court, and even we are impleaded in the civil suit as a defendant number 6 and 7. However, the Lanit Trial Court not strictly follow the order passed by this honorable court in RFA 16 of 2010. Then, the Lanit Trial Court never discussed based on the evidences adduced before the court, my lord. They just reiterated. They just paced the submission made by the parties before the court, without specifically mention the reason why that order has been passed in each of the issues. Even though we challenge nearly all the issues framed by the court has been decided in favor of the other side, not our side. However, in spite of we stated, we urged about all the issues. However, for easier convenience of the decision, my lord, I will go into.
Okay, so this is the judgment, and why you were aggrieved
yes,
by
my
this
lord, yes.
judgment is in your chart.
Yes,
is it?
my lord. Yes, in my chart. As per
okay.
my chart. For
So-
number 1, my lord.
Okay, so these are the issues framed. Where are the issues framed? Let's look at the issues framed first.
Issues has been framed.
What were the issues framed
Page.
in the judgment? Because that we'll have to look.
In the judgment.
Or have you mentioned it in your chart? No.
In my chart, I just stated what.
Okay,
I
then
am
let's look at the
challenging.
issues framed.
At page 867, my lord.
Then we'll know what the case is all about, isn't it? Yes.
867.
All of the issues were against you, but let's see what
Even
is-
we
okay,
challenge
1,
each-
2 not required,
Yes, my lord.
3 not required, 4 not required, 5 not required to be read out, 6
My lord.
not required, 7
I'm concentrating in
on Issue
in
number?
issue number 3, 7, 8,
3
10.
is barred by limitation.
Yes,
not
my lord.
required.
3, 7.
So 3 was against you also, is it?
Yes, my lord.
Okay.
3, 7, 8, 10, 14, 15, 16, 17, and 18. That is in 1 point, my lord.
Also, it was also held that it was barred by limitation.
Yes, my lord.
Okay. Then 7 is what? So read the issues which you are unhappy with her. Number 7.
I already chosen my ground of appeal in the chart, my lord. In the chart. Specific elements of that issue.
No, but before looking at the chart, we'll have a fair idea as to what was considered by the trial court in the civil suit, and then we'll look at the chart.
Okay.
Isn't it? Because then we'll have some idea. You know what is going on, but
Okay. Yes, my lord.
So the first issue, number 3, the court held that it was barred by limitation. Is it? Then the second one?
The second one is whether there is cause of action in favor of the plaintiff and against the defendants. Number 3, whether the suit is barred by limitation, doctrine of estoppels and acquaintances.
So this was decided in your against you, isn't it?
All issues, my lord.
Number 4 is not required. Number 5 is not required. Number 6 is not required. So read number 7.
Yes, number 7. Number 7 and 8.
What is 7? Issue number 7.
7, whether the defendant number 1 had inherited permit number 191 of 1974, White Earthship memo number dated 14/3/2000 or not.
So this is okay. What's wrong with this? Defendant number 1 will be whom? Defendant what?
My lord,
what's in the
we
Biala,
just
is
trying
it?
to state it that at the time of issuance of that heirship certificate, as per the land renewal and settlement order, that is impugned order in civil suit, already the not existent.
Okay. So number had inherited permit number. So
That's much, my
he
lord.
can inherit this thing, but okay, permit number 191 was not in existence. That's according to you. This landed property, is it? Okay.
Then number 8.
You cannot inherit a property that is not existing. That's your
Yes,
point.
that's
Okay.
much only.
Okay.
At that time, there is no inexistence of that property.
191.
Yeah, that's only.
already mutated.
Yes,
in a
in the name
different
of Biazao,
LLC.
and the same has been compensated by the award number 9
Okay.
of 1989.
By what?
Award number 9 of
Award number?
1989. 9 of 1989.
9 of 1989. Okay, so this is no longer existing.
We are not interested in whether the owner of who will be inheritance of that or not. However, at that time, there is no existence of that permit number.
Okay, so 191. No, just come back. You're saying that this thing award was already, that means it was already acquired.
Yes,
by
my
you?
lord.
Why-
Yes, my lord.
Okay, this is acquired. Okay. Acquired and award given. So he cannot inherit this land.
Yes,
That
my
is your
lord.
point.
There is
Okay.
no more land.
Already acquired. No, the land is there,
No.
but it's already acquired by
Yes,
you.
my lord.
Okay. By the respondents, you are the defendant's number. What in the defendant's number?
Number 6 and 7.
6 and 7. Okay. Then
Number 8, whether the defendant number 1 had sold his land covered by permit number 191 of 1974 to the plaintiff at any point of time by executing in rem natutlung dated 12/4/2002 and sale deed dated 19/4/11/2013. If so, whether the said in rem natutlung and the said sale deed are valid in the eye of law, my lord. In this regard,
the civil suit,
that is the main issue in the civil suit
okay.
prior to we are impleaded as a defendant, because the dispute is between Sai Thang Pui and Tanzawa at that time, my lord.
Okay, so the learned trial court decided that this Indram Tutung is valid, is it? Which you are unhappy. Because again, the land is 191. So the learned trial court said that this sale deed is valid, is it?
But,
From the issues, you can just decide, tell me what is the judgment?
because, my lord, let me see. In the last sentence of that decision, my lord, therefore this court is of opinion that the plaintiff had purchased page 879. Page 879, 879. In the last sentence, therefore this court is opined that the plaintiff had purchased half of the land property covered by permit number 191 of 1974, facing to what ISO site from the defendant number 1 for a sum of 30 lakhs. Therefore, this issue is partly decided in favor of the plaintiff. My lord, in this case, that is that the trial court not decided evidence and a circumstantial evidence also, my lord, in this regard, because the issue is that due to the plaintiff claim the land of the respondent number 2, Tanzawa father's land. However, the respondent number 2 stated that we never sold at any point of time his land to Sai Thang Pui. Then file a lodging FIR also. There are so much arch. Then we can see in the written statement also. I am come to as per the chart.
Okay, let's go to the chart then.
Yeah.
If we don't understand, we'll come back to the issues. Okay, because a case can be understood from the issues framed and how the issues were decided. So maybe in the chart itself, we are discussing these issues. Okay.
Regarding this issue number 8, my lord, serial number 3 of my chart.
So if you want, we can discuss your chart. Okay. From
Because
serial number
I'm
1.
going in
And
order.
to
It may be.
explain,
Yes, my lord.
explain if you have already mentioned this. So let's look at serial number 1.
Yes, my lord. From serial number 1, my lord, the learned trial court goes beyond the order dated 16/9/2021, passed in RFS 16 of 2020.
This is by the High Court, isn't it?
Yes, my lord, I
RFA?
already read out that order.
Yes.
That is page number 279 to 281.
Yes.
That is the order passed by this court. Then there is a direction, some direction has been given. Then number 1, without filing any miscellaneous application for amendment of plaint, the respondent number 1 plaintiff submitted her recast plaint by changing almost all Sai Thang Pui Silo, yes, the plaintiff.
The respondent number 1.
Yes, now respondent number 1 in the civil suit plaintiff. Submitted her recast plaint by changing almost all the stand taken by her in her old plaint and incorporating a new development of the developing her case, especially para 26 of the plaint. Claim area changed from 27 bigas to 25 bigas, and para 30, 31, 32, 33, 34, and 38 are totally changed, my lord. That is, supposing they apply for impleadment, they may be permitted. However, without filing any miscellaneous application for amendment of his petition, his plaint, he just submitted recast plaint without prior permission of the court, my lord. That is one of the point of my ground. Then number 2, one of the plaintiff, namely Lalnunea Masailo, is left out without mentioning the region in the recast plain, my lord. My lord, the earlier plain, my lord,
So there were two plaintiffs in the previous
yes, my lord.
civil suit. Is it?
At page number, my lord, at page number 1, that is civil suit, earlier civil suit, 59 of 2016. Plaintiff number 1 is Saithang Pui Silo. Number 2 is Sri Lal Nunnem Silo, son of Lalpara Silo, Jaltang, Aizol, Mizoram. Recast plain.
Anyways, it's okay if you have mentioned this.
In the
Because
recast
page
plain,
one is,
he left out without mentioning the region why the Lal Nunnem left out in the recast plain, my lord.
okay.
C, my lord. Respondent number 1, plaintiff, namely Saithang Pui Silo, already submitted her examination in chief based on her old plain, and the same has been cross-examined by the counsel for the defendant at that time, that is state defendant. Then later on, after recast plain, she submitted her examination in chief based on her recast plain. However, the learned trial court never decided on which examination in chief the court will be relied upon. That was in violation of the order dated 16/9/2021, passed in RFS 16. In the RFS 16, my lord clearly stated that the court will, whether you will rely or retain, should be clearly decided. However, there are true examination of the plaintiff, Saithang Pui. However, the court never stated that based on,
But according
never
to you,
prefer.
which plaintiff was the court relying
In the
on?
meantime,
According to you, as per the judgment, which plaintiff did the trial court rely on?
Yes, my lord.
In the
In the-
judgment?
Yes, my lord.
What? Yes. Tell me which judgment?
Yeah.
The first one or the second?
Yeah.
According to you, the learned trial court had then relied on the first plaint or the second plaint?
Second plaint, as per
the recast.
judgment and order.
Okay.
However, all the plaintiff witnesses adduce evidence before the court as per the old plaint, except Saithang Pui, all her three witnesses based on the old plaint. That is why.
But the trial court relied on the recast plaint.
Recast plaint that was supported by the Saithang Pui only, my lord. There is no any other evidence. He just pays the submission made by Saithang Pui. Then number D, the petitioner the respondent number 1 plaintiff, or here I say, have 4 witnesses, including her, the Viz Vanel Tanil Nunmoy and Thang Lian Mga Guite, based on her old plaint. However, as per Honorable Court Order dated 16/9/2021, the learned trial court shall clarify as to whether he will be relied upon or retain those evidences already taken prior to implement of Union of India in the case, but the trial court failed to do so. Then E, the respondent number 2, defendant number 1, namely Thanzawa, also filed written statement based on which he submit his examination in chief.
So what's wrong with this? It's okay?
Here, my lord, respondent number 2 is Thanzawa. In civil suit, he is defendant number 1. Also submitted written statement, and his examination also based on all written statement. No other written statement has been filed later on after amendment of the recast plaint, my lord. Then F, the state respondent defendant also filed written statement based on
so
written
you're saying
statement.
that no new written statement was filed?
Yes, my lord. But the court never stated that he will be rely upon the written statement because evidence has already been done. Examination in chief of Thanzawa also based on his written statement, my lord. In the meantime, state government.
Just come back to C, okay? Also filed written statement. This is new statement.
No,
written,
my lord, the old one.
Old one.
Yes.
Based on which he submitted his examination in chief.
Yes.
So he did not file a recast.
Yes, my lord.
The old one was relied
Yes, my lord.
upon. Okay.
Then F, the state respondent defendant also filed written statement.
Obviously, now you're a party.
Yes. Based on written statement filed by the state government, their true witnesses, namely Srimati Martin Lupuya, Under Secretary Revenue Department, Government of Mizoram, and Sri Rin Zamlawa, Joint Director of Survey, Revenue Department, Government of Mizoram, also submitted their examination in chief and cross-examined the same. However, except all the above witnesses of the parties, except this is a spelling mistake, my lord, except Srimati Saithangpui's adduced evidence based on the old plain, old written statement, old plain and old written statement. In the meantime, the learned trial court never decided by passing order which part or portion of evidences which already taken prior to implement of Union of India before the court will be retained or will be relied upon, while the old plaint and the recast plaint are differ to each other, my lord. That is relating to issue number 8. No, yeah, relating to not compliance with, not compliance with.
All the above witnesses or
All the witnesses mean the plaintiff witnesses as well as the defendant witnesses already adduced before the court as per their old plain, old written statement, except Saithangpui Silo.
so this will all be then if the cross-examination is relying on the old distinct plaint, while in the new plaint the plaintiff has improved upon
Yes,
the
yes, madam.
plaint, then it will be in the advantage for the defendants because they're not considering the
Yes,
improved
in
one.
fact,
It
my
is in
lord,
your
it is
distinct
better for
favor.
us, my lord.
It
The
is better
judgment
for
on
you.
yes, my lord. In fact, it is better for us. However, subsequently, the court passed order without discussing the evidence. This is the main
Okay.
problem.
Okay.
Without
anyways.
highlighted any evidence adduced before the court. That is my problem. He just pays the submission of Saithangpui Silo in the oral judgment, impugned judgment and order. In fact, it is better for us. However, without discussing all that evidences.
Okay. Anyways, point
that
number
is-
2.
regarding the limitation, my lord, Para 2. The learned trial court wrongly decided issue number 3, whether the suit is barred by limitation doctrine of estoppel and acquaintances. The learned trial court failed to appreciate the stand taken by Union of India as well as the witnesses, as well as the deposition of witnesses while deciding issue number 3. There might be cause of action against defendant number 1, that is state defendant. However, there is no cause of action against Union of India.
No, there might be cause against. I thought defendant number 1 was that Bialzawa or something.
The number 1 is Thanjawa, my lord.
Thanjawa.
There
Then
may be
might be cause of action against defendant number 1. That is
Thanjawa.
Thanjawa. You
And
said
also state,
And the
because
state,
they
okay,
converted
yes,
their
yes,
parts
okay.
into a bigger land pass. There might be a issue between them. However, there is no any cause of action against Union of India. Para A, my lord, as para 4 of written statement filed by Union of India stated that headquarter engineer project Puspak started occupied the land in question from 1963. That is at page 156 to 158. B. In the year 1970, the Office of Mizo District Council Executive issued Departmental Pass number 4 of 1970 to BRO. BRO means Border Road Organization. That is the name of BRTF. The land in question has been acquired by award number 9 of 1989. That is from page number 456. My Lord,
No, page
let me
number
see.
501 to 512.
484 is departmental pass, the first pass.
What?
484.
Oh.
484. Page number 444, 84 is departmental number, pass number 4 of 1970. Even we started occupied from 63, however, we have departmental pass in the year 1970. If I may read, my lord, the Executive Committee of Mizo District Council is pleased to allot the area of land mentioned below temporarily to the Border Road Organization for their temporary settlement while undertaking the construction of road on terms and conditions laid down below. Number 1, pass is purely temporary and will stand valid up to 31/12/1971. The exact location of the site in each case will be selected by the border organization and the VC president concerned. Further, each VC president is hereby authorized to act on behalf of Mizo District Council to take up compensation cases arising thereof, if any, and to report to the revenue officer, Mizoram
See,
District.
this is valid up to 31/12.
Yes, my lord.
1971.
Thereafter,
What
my lord.
happened after that?
Thereafter, a formal land acquisition proceeding has been initiated. Then we acquire Vite Award number 9 of 1989. That is at page 486.
Okay, you've mentioned that. Huh? Yes.
We started occupy the land from 86.
Then you have occupied the land since then,
yes.
till date.
Yes.
Oh,
Then award number 9 of 1989 is at page 10486.
Okay, no need to look. There's
My
an
lord,
award,
here.
what do you want to say here?
Okay.
Page number?
486.
486.
Then see now,
Yes, what do you want to point out here? 486.
and it's subsequent award 2 of 1992
So how
and
much was he
1
paid?
of 1994 is also there. There is some dispute, they settle again another award. That is at page 510 to 512.
Permit number 683, is it? 510? Award number 2 of 90.
2 of
Yours
1992
is
and
permit
1 of
number?
1994. All are enclosed here in my lord. In the
So the landed property acquired by you is covered by which permit? By which permit? 683?
89, my lord. Here I may so later on the land of the Biaza was also there in the award, my lord.
Where, which one?
My
Permit
lord, if I
number
may.
68363, this was acquired, value of the land. So in page 510 and 511, where is the land acquired? Which one?
Same land, however, that is subsequent award only due to some dispute. In the first award, my lord, my lord, if I may, in the award number 9 of 1989, at page 490, my lord, the name of Biazawa,
It's there?
at serial number 48, 490. Serial number 48, Bialzawa LSC. This LSC was
103.
yes, arising out of periodic pata 1 of 1977, that was originated from the present issued, my lord.
So it's
Permit
okay.
number.
So 490, page 490, his name is there, Bialzawa, okay, his land.
yes.
But the other documents which you're showing me, 511,
Yeah.
512, where's his
My
name?
lord,
Because
I
for
just
some
showing,
reason-
I am just trying to say that
Okay, this
we
is-
acquire,
you're-
we
you're-
occupy
you're
the
not-
land as per law. Oh, that
So
much.
your name is not mentioned here. This is the dispute is not regarding you, is it?
Yes, my lord. That
this
is
is
why
just
there is
some
no
dispute,
dispute against Union of India.
Ah,
That
okay.
is why we can count limitation. Then D, my lord, finally, the land measuring 161.50 bigas, 53.83 acres handed over to BRO, free from all encumbrances. Vite DC letter number so and so dated 29 January 2004, along with map. That is why, my lord, there is no any encumbrances. Then we are handed over free of cost. That is why there could not be continuation of cause of action against Union of India in favor of the plaintiff. Then I have one citation, Z and Siama, my lord. Then here in this citation, the limitation also be applicable in Mizoram, my lord.
What is the citation number?
It may not be, my lord, I have a copy.
Reported where?
It may not be reported, my lord. I have a copy at para 13, my lord.
This is not a reportable judgment.
It may not be reported. Yeah, my lord. Therefore, the suit has been filed by respondent number 1 plaintiff after lapse of 53 years from the date of occupation of the land, that is from counting 1963, and 43 years from the date of departmental pass number 4 of 1970, and 27 years after acquiring the land in question by Union of India, that is 1989, because each bear by limitation against Union of India. However, there might be cause of action between the private respondent number 2, Tanzawa, and the state also, because their land has been converted into a bigger area, so and so. That has been taken place. There may be cause of action prior to Union of India has been implemented. However, against Union of India, we occupy the land properly as per law, then there could be no cause of action. That is why the civil suit is purely voided by law of limitation. Then in the meantime, the landed trial
So
court,
J. Tanzama's judgment, para 13, what is it?
they stated that, my lord, at para 13, my lord, the eventual conclusion of this court are to be found in para 16, which is quoted below, with the clarification that para 12A refers to herein pertains to autonomous district council or regional council in the state of Meghalaya, whereas in the instant case, the relevant provisions of the 6th schedule would be paragraph 12B as initiated applicable to the Union Territory of Mizoram and therefore to the state of Mizoram.
So what was it applicable in your instant case?
My lord,
Why are you citing this para 13? I'm not understanding.
at 16, my lord, it would thus be clear that
Okay, para 16.
on the constitution of district and regional council, paragraph 19 cases, to operate and power of the governor becomes conterminous and cease to exist. Simultaneously, the power of district or regional council becomes operational to make law.
So
and-
why are you quoting this judgment?
My lord, that is why, my lord, earlier to that judgment, limitation will not be counted in Mizoram state. But as on from this,
Okay, so you're
yeah.
okay on the limitation.
They never-
So
they
you're
never-
saying that limitation is to be counted based
Yeah.
on this.
Yes, my lord. after that, they never consider strictly regarding the limitation due to some regional and district council court so and so rules, my lord. However, after the Supreme Court decided Zethan Siama versus State of Mizoram, the
So you're saying
limitation
the period of limitation
could
now
be-
sets in. Okay,
could be
because of this
applicable in
judgment.
Mizoram.
Oh, okay. Now I'm getting your point.
My lord, I already regarding issue number 8, that is Parachi. If I may. The Landed Trial Court wrongly decided issue number 8 whether the defendant number 1 had sold his land covered by permit number 191 of 1974 to the plaintiff at any point of time by executing in rem natutlung dated 12/4/2002 and sale deeds dated 19/11/2013. If so, whether the said in rem natutlung and the said sale deed are valid in the eye of law. The Landed Trial Court has failed to appreciate and analyze the material facts / document surrounding the circumstances of the case and also failed to appreciate fully the evidences that were made available to him in the plain, the written statement, examination in chief, and cross-examination of the witnesses of the party. A. The respondent number 2, now the defendant number 1, namely Tanzawa, filed written statement at para 8, 12, 11, 12, 14, 16, and 18 of the said written statement clearly stated that the defendant number 1, namely Tanzawa, never sold his land covered by permit number 191 of 1974 to the plaintiff, namely Srimati Saithang Puisailo. At any point of time, he came to realize that the plaintiff has fabricated sale deeds by forging his signature. As a result, he submitted FIR against the plaintiff to the officer in charge, Bongkon. In the meantime, the same statement has reiterated in his examination in chief. B. However, in his cross-examination in chief by the counsel for the defendant, the respondent number 2, defendant number 1, had totally changed his stand taken by him in his written statement as well as in his examination in chief. The written statement, examination in chief, and cross-examination are contradicted to each other. However, the Landed Trial Court does not take into account all the contradictory statements of Sri Tanzawa. My lord, if I may permitted to read over the written statement of the Tanzawa. Especially for para 8, 12, 14, 16, and 18. And
They are at page
para 8, my lord.
166 or what?
167. It started from 166. Para 8 is at page 167.
Yes.
My lord, para 8, the avertment made in para 1, 2, and 3 of the plain are absolutely false and completely denied, as the defendant number 1 has never sold his said land covered by permit number 191 of 1974 to the plaintiff at any point of time. The answering defendant came to realize that the plaintiff have fabricated a sale deed by forging the signature of the defendant without his knowledge and consent. As a result, the defendant number 1 had immediately submitted FIR, first information report, against the plaintiff to the officer in charge, Bongkot PS. Then at para 12, page number 168, the avertment made in para number 7, 8, 9, and 10 of the plaint are correct to the extent that the defendant number 1 is the legal and lawful owner of the land covered by permit number 191 of 1974, and the defendant number 1 has never sold his land to the plaintiff or anyone for the matter. It is reiterated that the entire claim of the plaintiff in the present suit are completely incorrect and without any basis whatsoever. As the power of attorney dated 19 March 2002, executed by the defendant number 1, it is submitted that the defendant number 1 had filed revocation of power of attorney on 18 February 2015 before Notary Public Registration Fight so-and-so 2015. The plaintiff are to speak proof of the avertment made thereunder. Then, para 16. The submission made by the plaintiff in para 16 is totally false, completely baseless and ridiculous. It is reiterated that the defendant number 1 has never sold his land covered by permit number 191 of 1974 to the plaintiff through number 1 Saitang Pui Silo at any point of time. As soon as the defendant number 1 came to know of the so-called sale deed dated 19/11/2013, as well as Poisadon Dan Kim Jong, are fabricated and forged by the plaintiff, the defendant number 1 has completely submitted FIR first information report to the officer in charge Bongkon Vite, PS Vite GDE number so and so dated 26/2/2015. Thereafter, the defendant number 1 submitted application to the defendant number 3, Director Land Revenue and Settlement Department, not to process with the application submitted by plaintiff number 1 Saitang Pui for a portion of permit number 191 of 1974 in favor of various names who are perfect stranger to him. Then, para 18. The content of para number 18 of the plaint is not admitted. It is respectfully submitted that the defendant number 1 has submitted FIR to the officer in charge Bongkon Police Station to the effect that so-called sale deed dated 19/11/2013 was fabricated by forging the signature of the defendant number 2. Unfortunately, the Bongkon PS has taken no appropriate action to find out the person who has fabricated the sale deed and forged the signature of the defendant number 1. Incidentally, there is no limitation period prescribed under the relevant act for taking cognizance of the same. My lord, here, in the written statement of the Tanzawa, the present respondent number 2, they totally not agreed with the submission made by the plaintiff. Then, based on this written statement, he submitted examination in chief. However, the stand taken by respondent number 2 has changed from cross-examination, my lord. That is from page number 226. Page number 224 is examination in chief, is
It's
more
the
or
same?
less same to the written statement.
Oh, okay.
However, from the cross-examination, everything has been changed, my lord.
Okay.
Here in cross-examination, my lord,
So maybe the cross-examination was done so well that he had to, is it?
my lord, in the meantime, in the middle of the case, everything has been changed. Then, my lord, if I may, my lord, para 1, it is a fact that Saitang Pui plaintiff number 1 is owner of half of the landed property. Now, he clearly admitted, even in the written statement, he is totally disagreed and filed FIR so and so. However, at the cross-examination, it is a fact that Saitang Pui Silo plaintiff number 1 is owner of half of the landed property covered by permit number 191 of 1974, my lord. That could not be mistake, my lord. That is why I have citation for that, my lord. 2018 10th SCC 707.
2018,
10 SCC 100 707.
707.
Suzuki Paras Rampuria Shooting
Para-
Private Limited. Suzuki Paras Rampuria Shootings Private Limited.
Okay, 18,
At
10,
page number
107.
712. Para 2.
Para 2.
Point number 12.
Yes, wait.
A litigant can take different stand at different time, but cannot take contradictory stand at the same
Wait,
time.
just a sec. Para
Yes.
2. Come to
Para-
2.
Para 2, point number 12.
Just a second. 2018, 10 SCC 107. Have you got that right?
707.
707.
Yes, my lord. Page
Now come
number,
to para 2.
page number 712, para 2, point number 12.
Wait, just scroll down. Let's see the citation. Is it correct?
A litigant can take different stand at different times, but cannot take contradictory stand in the same case.
Are you sure your paragraph is correct?
Page 712.
See, we're not.
Second paragraph, point number 12.
Let's see this thing.
We already checked the SC also, my lord. It's same.
From the SCC,
Yes,
you
ma'am.
cannot be.
As per the book, we checked, already checked from the book, my
Okay,
lord.
no, it is not para 2, it is para 12. That's why
Para-
you're confusing us.
Oh. Here,
There's
it
no
pa-
para 2, there's para 2 is different, it's para 12. That's why you're confusing us. Yes,
Okay.
para 12. Please read para 12.
I'm sorry, my lord. 12. This one. A litigant can take different stand at different times, but cannot take contradictory stand in the same case, my lord. Here, defendant, now the present respondent number 2, file written statement and also file examination in chief. However, having intentionally in cross-examination, he totally changed his statement. That is not permitted by this citation, my lord.
Okay.
Then second citation, 2022 2 SCC 25.
Para?
Para 41. Para 15. Sub-point 15.
Para 41 or para 15?
Para 41, page 41.
No, we don't want the page because we are not reading from a book. There's no page number here. So just come to the para. It's paragraph.
Third paragraph.
Para 3.
Sub-point 15.
Just come to para 3.
Is that
If it's from SCC.
15 minutes, I may be read, my lord. A party cannot be permitted to blow hot, blow cold, fast and loose, or probate and reprobate. That is
Para
only.
13 or para
15,
3?
15.
Para
15.
15. 1-5.
1-5.
Para 15 is the learned single judge dismissed the writ petition. If it's from SCC online, we should be able to.
I'm looking from the book of the SCC, my lord.
If you're citing SCC, then you should also tell us from SCC. Even if you're reading from the book, you must have downloaded from the SCC, isn't
My
it?
lord, I'm sorry, then
Then it's para what? There are no paragraphs or what in your hard copy?
in my copy, 15, 1-5.
So come to para 15. 1-5.
A party cannot be permitted to blow hot,
Para
blow
1-5
cold.
is the learned single judge.
Third paragraph,
There's come to para 3. Let's see what is para 3.
parachute, yeah.
Central Power Research. So you had got your citation from SCC online, isn't it? If
I
it's
have learned from the book, my lord. Okay, my lord,
or notebook?
I may submit it again later on. Okay.
If you're cited SCC online, open your SCC online. Okay, not something else. Then we can be on the same paragraph.
2022 to SCC 25. I'll submit the paragraph later on, my lord.
Okay.
Then I
So
have
what
another
is it?
citation.
What is it? What does this thing say? The same one sentence.
They just stated that the party cannot permitted to blow hot, blow cold,
But
fast and loose, and
the fact of that case and the present, what you're trying to present, we'll have to see. Okay. What happened to the parties there?
It's on para 27.3.
Okay, it is para 27.3,
26, I think.
not para 41.
Para 7.3.
Para 27.3, then there is a sub-para 15. Okay, so when you say para 15, you forgot the para 27. Within para 27.3, the court had referred to another judgment where in that judgment it is para 15.
Okay.
Okay, so 7, yes. Now you can read, but the court had referred to the judgment of the apex court in Rajasthan versus State Industrial Development. And in that case, it is para 15. But in the case where you are citing, it's para 27.3. Okay.
Okay.
Find the difference. So, okay, fine. Next citation.
Next citation. Uh, 2010 14 SCC 38. Page 51.
38. Para 38.
Yes, my lord. Page 38.
We don't have the page
But
numbers
page
here.
51. 51.
Para?
The principal, point number 21, my lord. Para 2, point number 21.
It's para 21.
Para 21.
Yes.
Okay. It's para 21, not point. You see those little things? See, there's a box. Okay. Next to the box, there's a number. That's a para number. Para, yes, 21.
Okay. The principle that person who does not come to the court with clean hand is not entitled to heart on the merit of his grievances, and in any case such person is not entitled any relief, if applicable not only to the petitioner, to the petition filed under Article 32, 2 to 6.
So you're saying that he's not coming with clean hands
Yes, my
because
lord.
before his stand was there, then
Yes.
somewhere in between he had switched sides.
Yes.
It appears. Okay. Then
Then next, para 4, my lord. The Lanet Trial Court wrongly decided issue number 10, whether the area boundary of LSC 103 of 1985 in the name of Sri Bialzawa pro forma defendant number 5 covered the entire area of the land covered by permit number 191 of 1974. The Landed Trial Court never appreciated the written statement, the position of witnesses, and the document available on record for making decision while deciding issue number 10. A The state respondent defendant file written statement at para 10, 14, 15, and 16 of the written statement filed by the state government of Mizoram. It is clearly mentioned that the LSC 103 of 1985 in the names of Biazawa covers the entire area of land covered by permit number 191 of 1974. It is stated at para 10 that the answer, para 10, my lord, the written statement is at page 178 of the paper book.
What does it say?
Para-
Read from your the string
my lord.
table, it's okay.
Especially para 10, 14, 15, and 16. Para 10. With regards to para 8 of the plain, the answering defendant would like to state that it is clearly stated in the government letter, right, so and so dated 24 November 2015, that permit number 191 of 1974 was already converted into periodic pata number 1 of 1977, area 2 bigas by Pulyantudaya by superseding permit number 191 of 1974 to Pulyantudaya again sold his periodic pata number 1 1977 to Pubyalzawa, and mutation was done according on 10/6/1977, and the same was again converted into LSC 103 1985 in favor of Pubyalzawa, and all the above transaction was done before the death of Pulyantudaya on 20/2/1986. Further, the heirship certificate attached in para 4 of the plain is not valid for the suit land, as Liantudaya no longer has the ownership right title over the suit land in 2000. Then para 14. With regards to para 26 of the plain, the answering defendant would like to state that, as stated at para 8, Pubyalzawa has legal ownership right over the suit land ever since mutation of periodic pata number 1 of 1977 was done in favor on 10/6/1977. The heirship certificate issued to the defendant number 1 on 14/3/2000, and even the executed in Remnatlung dated 12/4/2002 between the plaintiff and the defendant has no legal validity over the suit land. Then at para 15. With regards to para 27 of the plain, the answering defendant would like to state that, as stated at paras 8 and 26, the ownership right over the suit land already goes to Pu.F. Bialzawa on the strength of periodic pata number 1 of 1977. Besides, it may be paramount important to note that permit number 191 of 1974 was not longer in existence, as the same had already been converted into periodic pata number 1 of 1977. Thus, there could be no ownership right to transfer in permit number 191 of 1974. Then at 16. With regards to para 32 of the plain, the answering defendant would like to state that, as stated at above paragraphs, the suit land bearing periodic pata number 1, 1977, which was converted from periodic pata number 191 of 1974 and subsequently converted into LSC 10389, is already mutated in favor of F. Bialzawa. Thus, it is humbly prayed that the instant suit may be dismissed by upholding the government letter dated 24/11/2015 for the interests of justice. That is the written statement by the state. That written statement has been supported by two witnesses, Srimati Martin Dalhupuy and the secretary, and Joint Director Rin Zamlawa, and it's corroborated to each other with the written statement. However, their statement before the court had never ever highlighted in the impugned judgment and order, my lord. Then that is the written statement. B, my lord. The said written statement has been supported by our two witnesses, Ms. Martin Lalupui, Under Secretary, Land Revenue and Settlement Department, and Sri Rin Zamlawa, Joint Director of Survey Revenue Department, Government of Mizoram, by adducing evidence, reiterated the same in their written examination in chief at para 2, 4, 5, 6 respectively. The statement has been reproduced again in their examination in chief, my lord. The examination in chief, it page 232, 239. C. The LSC 103 of 1985 of Bialzawa was enclosed by the plaintiff in her old plane and marked as Annexure 7. My lord, page.
Where are you reading from now? Your notes?
Page number 325 to 326.
Okay.
But in the new
was
plane,
enclosed.
in the recast plane, not enclosed. However, it already quote document, my lord, I enclose it.
Oh.
It page
So in our
325.
old plaint, it was enclosed, but not in the recast.
Yes, my
Okay.
lord. However, the state government in their written statement, they enclosed this letter.
Who enclosed it?
Enclosed by the state
Okay.
in their written statement.
Oh.
That is at page 325. That is, my lord, that is the
The LSC was
LSC of
enclosed by the
Bialzawa.
plaintiff in our
Yeah.
old plaint.
My
Okay.
lord, it's not very clear from here. Type of paper.
So what are you trying to point out here? I'm not getting it. 325.
321.
Let's come to page 325. So you're taking me to page 325, is it?
325, yes, my lord. In page number 326, my lord, it's clearly stated that the whole area has been converted.
This is,
My lord, in the next page, that is page number 326. This one, Ram area 2622.49 square meter equal to
this is annexed by whom? Annexed by the plaintiff?
Yes, the annexure 7 of the plaintiff, all plain. Then the state government also enclosed in their written statement.
So this was enclosed in the written statement of whom? Of whom?
Of the state, my lord. The LSC itself clearly solved the problem, my lord.
Where is the
That is-
LSC?
That is at page 325.
This is the boundary description.
My next page, my lord. This one, Ram area 2622.49 square meter equal to 28217.99 square feet equal to 1.95 bigas. Ania layman lag nan chuan 2 bigas. Bigat ni 2 bigas.
Okay, so this is Bialzawa's land.
Yes,
isn't
my
it?
lord. Hey, here periodic pata number 1 of 1977 to a supersede ni. Hey, here tikha le site LSC. Heta hani na retype kan ron thil tela. Hemi LSC here. Hemi LSC hi
This
is
is
convert march on periodic pata number 1.
103 of 1985.
Yes, my
isn't
lord.
it? This was given to
Sorry, my lord.
Bialzawa.
They already sold to Bialzawa and periodic here, my lord, I write.
This will supersede periodic pata 1 of 1977. Okay, fine.
Yes, my lord. Biazawa covers the entire area of land and covered by permit number 191 of 1974. It is stated that the paraten of the answering defendant would like to state that it's clearly stated in government letter by so and so dated 24th November 2015 that the permit number 191 of 1974 was already converted into periodic pata number 1 of 1977. That is the present. Then area 2.00 biga by Puliantudaya by superseding permit number 191 of 1974. Puliantudaya again sold his periodic pata number 1 of 1977 to Biazawa, and mutation was done according on 10/6/1977, and the same was again converted into LSC 103 of 1985 in favor of Biazawa, and all the above transaction was done before the death of Puliantudaya on 22/1986. Further, then the said written statement has been supported by two witnesses, namely,
You're reading from where now?
my lord,
Your
para 4,
para 4 of
A,
what?
para 4A. I just read out para 4A
Para 4 of what?
of my chart, my lord.
Now you're coming to your chart. Okay.
The reason why I'm showing this pass is very relevant. The pass itself clearly solved the problem.
So sometimes you're reading from your past, sometimes you're reading from your chart. So just from your chart,
I'm
now
sorry,
we
my
are
lord.
reading para 4.
Yes. No,
Para 4A, is it?
yes, my lord.
Okay.
I'm
I'm trying to follow you, but you're not telling me properly as to from where you're reading.
I'm
yeah?
sorry, my lord.
Okay, 4A. Yes.
Here, 4A, we stated again that the process of converting from
Same, isn't it? What you have just read out, it's the same in 4A.
Yes.
Para 10, 14, 15, 16,
yes,
which you have already
I just
read.
read out, my lord.
Okay.
Then it is now at para 10, 14, 15, and 16 of the written statement filed by the state government of Mizoram, it is clearly mentioned that the LSC 103 of 1985 in the name of Bialzawa covers the entire area of the land covered by permit number 191 of 1974. It is stated at para 10 that the answering defendant would like to state that it is clearly stated in government letter by so and so dated 24 November 2015 that permit number 191 of 1974 was already converted to periodic pata number 1 of 1977, area 2 bigas, by Puliantudaya, by superseding permit number 191 of 1974. Puliantudaya again sold his periodic pata number 1 of 1977 to Pu F. Bialzawa, and mutation was done according on 10/6/1977, and the same was again converted into LSC 103 1985 in favor of Pulal Bialzawa, and the same, all the above transaction was done before the date of Puliantudaya. Now, I'm trying to show that this LSC, which originated from permit number 191 of 74, they already converted, then already mutated again in the name of Bialzawa, and now converted again in LSC, and the same LSC had already been acquired. There is no more permit number 191 of 1974. Then in B, I stated in orderly, my lord. The said written statement has been supported by two witnesses, namely Srimati Martindal Lupui, Under Secretary Land Revenue and Settlement Department, and Sri Zamlawa, Joint Director of Survey, Revenue Department, Government of Mizoram, by adducing evidence, reiterated the same statement in their examination in chief at para 2, 4, 5, and 6 respectively. C. The LSC number 103 of 1985 Bialzawa was enclosed by the plaintiff in her old plane and marked as Annexure 7. That is, in the said LSC 103 of 1985 of Sri Bialzawa at the last paragraph, it was written that this will supersede periodic pata number 1 of 1977, and a house site LSC is preferred from this. The LSC itself clearly reveals that the permit number 191 of 1974, which was later on converted into periodic pata number 1 of 1977 and again converted into LSC number 103 of 1985, superseded periodic pata number 1 of 1977, arising out of permit number 191 of 1974. Then the LSC itself also clearly stated that it superseded the whole pass of periodic pata number 1 of 1977. Then there is no more existing of permit number 191 of 1977.
So when they acquired, when the land was acquired,
Yes, my lord.
it
In
was
the next-
they acquired the LSC.
Yes, my lord.
Not the periodic
Yes.
pata. Okay.
At Paradi, my lord. At para 15 of Memorandum of Appeal, that is my Memorandum of Appeal, Union of India clearly stated that permit number 191 of 1974 was already converted into periodic pata number 1 of 1977, area 2 bigas. And Sri Liantudaya again sold his periodic pata number 1 of 1977 to Bialzawa, and mutation was done accordingly on 10/6/1977, and the same was again converted into LSC 103 of 1985 in favor of Bialzawa. The said LSC number 103 of 1985 of Sri Bialzawa has been acquired for the purpose of office complex of Project Puspak BRTF Vite Award number 9 of 1989 and already compensated. That award is at pace already shown, my lord. The name of Bialzawa is at serial number 48 and already compensated. Then F, the owner of LSC 103 of 1985, Sri Bialzawi is at serial number 48 of the said award. And as the above mentioned statement have been mentioned in the written statement of Union of India and also supported by their two witnesses, namely Chalming Thanga, Joint Director, and Sri Narendra Kumar Nishan, AE Civil. G. The respondent number 1, plaintiff, also admitted at para 8 of the plain that the sliced out portion of the land was converted into LSC 103 of 1985, which was then acquired for the purpose of office complex for the Project Puspak Vite Award number 9 of 1989 at page 200. Now, even though they are trying to say some portion of the land. However, they admitted that some portion has
Okay,
already
let's see this. Where did the plaintiff respondent number 1 admit? 287. Let's see page
page
287.
287. But they're not trying to say the whole area, but they admitted at para 8.
Where did they admit?
From the middle, my lord. One defendant, the defendant number 1 had come to learn about the state para 8.
Yes, para 8. You're reading para 8. You're reading the whole para or a portion?
Here in the last from 1, 2, 3, 4, 5, 6, 7, 8 line from the bottom, my lord. 8, 9, 10 line. It is humbly submitted that the defendant number 1's late father has sliced out an area of so and so from the area of cover by permit 191 of 1974, which he had sold to Bialzawa, who is defendant number 5, and thereafter the slice out portion of the
but
land.
here he says they had slide out an area.
Slice out, they're trying to say slice out area, but
Not the whole.
the
But
LSC
according to you, it is the whole.
Yes, the LSC itself clearly stated the whole area because it superseded the earlier LSC by this LSC. The LSC
I think
itself
this is the
shows
main
that.
crux of the case out here, isn't it?
Hmm.
That 191/74 permit, you're saying that the LSC 103 covers the whole
Yes, my lord.
area. But according to the plaintiff, it is not the whole area, and that there is still
Slight
land
portion,
property. I think that's the whole case here.
But they admitted slight portion is already acquired, but even not the whole area.
Okay, I think that's the main issue out here, isn't it?
Yes,
Whether
my
there's
lord,
any
the main
land
issue.
remaining.
Yes, my lord.
Okay, then we'll have to see on
H,
this.
my lord. The respondent number 1 plaintiff enclosed verification report on the claim of the compensation by individual on the proposed land to be acquired for Puspak BRTF Zemabo in the plain. The said report at Block 3, it is written that there is only one
Okay, wait,
claimant.
before you go ahead,
No.
what is the area of the permit 191/74? What is the landed area covered by that? Anywhere? 191.
191 is the whole area is converted into the LSC
So
of
what is
Bialda.
the landed area mentioned? The area covered? How many square meters, feet, anywhere mentioned? A copy of the permit is not available, is it?
My lord,
Because
if
here,
it already
if
there
it is-
in the
if it is
acquisition, my lord.
191/74 is the landed, is the permit, it should be covering a certain square meter or square feet, whatever, okay? And then the other LSC is having a certain area. Then if the area is the same, it will be clear. So anywhere
My lord, as
has it been mentioned, the area covered by the permit 191, and the area covered by the LSC 103.
my lord, here the LSC itself clearly stated that the whole area has been superseded, even
Okay.
site.
Yes, please go
Here
ahead.
in the block 3 verification report, that is at page, it started from 308, my lord. Then the relevant portion is at 316. At 316, my lord, that is block 3. That is the document of the plaintiff.
316.
316. The verification report is started from 308, then the relevant portion is at 316. Block 3, the last sentence, my lord. There is only one claimant of the compensation within Block 3, namely Bielzawa. There is no dispute within Block 3.
Okay, so there's 191/77, and later
That-
103, 1983
Yes.
is block 3.
Yes, my lord, at Block 3.
Then
However, the above evidences, along with document, has never analyzed by the Lanet Trial Court at any point of time. The Lanet Trial Court just simply reproduced the examination in chief and cross-examination of some witnesses without definite finding for deciding issue number 10. In the meantime, the deposition of witnesses of the state government as well as Union of India clearly shows that the area and boundary of LSC number 103 of 1985 in the name of Sri Bielzawa pro forma defendant number 5 covers the entire area of the land covered by permit number 191 of 1974. Supposing but not admitting the permit number 191 of 1974 covering area 29.48 bigas, there is no such huge space. There is no space for such huge area at the land in question. As such, there is no possibility of.
So the claim of the present respondents, is that 191 covers 29.48 bigas.
Yes,
Is
yes,
it?
my lord. However, after deducting, some portion had already been sold to Dr. Rilm Tuanga in Biazawa. They claim less than this after deducting those land settled by them. At para 5 of my chart, my lord. The landed trial court wrongly decided issue number 14, whether the order dated 24/11/2015 cancelling permit number 191 of 1974 is illegal and valid or not.
So
The
the,
la-
trial court said that this cancellation
Yes,
is
the
illegal.
cancel. Yes,
Is
my
it?
lord.
Oh, okay.
That is the main issue, my lord. The learned trial court has failed to appreciate and analyze material facts document surrounding the circumstances of the case, and also failed to appreciate fully the evidences that were made available to him, and the plain written statement, examination in chief, and cross-examination of the witnesses of the parties. Then A, the state government filed written statement and clearly stated the reason why the order dated 24/11/2015 by cancelling permit number 191 of 1974 was issued by Sri Thankuma, Secretary to the Government of Mizoram Land Revenue and Settlement Department properly, and the same has been done in compliance with Honorable High Court order dated 1/5/2015 in connection with contempt case C number 16 of 2015. The authorities of the Land Revenue and Settlement Department inquired into the matter and verified all the relevant and original record of LRNS with regards to allotment and settlement. The land of the petitioner Sai Thangpui purchased, and the following facts were revealed. B, the government written statement at para 10, 14, 15, 17, I already read out, my lord, clearly stated that the reason why permit number 191 of 1974 has been cancelled. C, at para 10 of written statement of state government stated that the answering defendant would like to state that it is clearly stated in government letter number so and so dated 24 November 2015 that the permit number 191 of 1974 was already converted to periodic pata number 1 of 1977 area 2 bigas by Pulian Tudaya. By superseding permit number 191 of 1974, Pulian
So it's
Tudaya.
only 2 bigas here.
Yes, I mean, I want to state that, my lord, even the evidence has been there relating to the reason why the order passed by Land Revenue and Settlement is genuine. However,
So
even though there
you
is,
say that it cannot be 29.4 bigas. It cannot be.
yes, my lord.
So you're saying that it is
That
only
is why,
2 bigas.
yes, earlier they converted, they increased the land of the petitioner from 2 bigas to 28.40 something bigas by the revenue. Then later on, they revoked that order by passing, as per in persons of the court, this honorable court order. They issued that order dated 24/11/2014. They clearly mentioned the reason why they cancelled the earlier order and cancellation of permit number 191.
You have already
Yes,
read that
already
out.
stated in
You
written
read that-
statement.
that order
Yes,
out,
but
isn't it? Yes.
nothing has been mentioned, nothing has been discussed in the judgment, impugned judgment and order. That is why we have filed this appeal. Then C, B, the state government statement at para 10, 14, 15, for your, my lord, I stated
Yes,
this one
yes.
for your kind understanding only, stated that the reason why permit number 191 of 1971 has been, 74 has been cancelled. C, at para, I already read out. D, my lord, D. At para 15 of the written statement of the state government stated that the answering defendant would like to state that, as stated at para 8 and 26, the ownership right over the suit land already goes to Bialzawa on the strength of periodic pata number 1 of 1977. Besides, it may be a paramount important to note that permit number 191 of 1974 was no longer in existence, and as the same had already been converted into periodic pata number 1 of 1977. Thus, there could be no ownership right to transfer in permit number 191 of 1974. E. At para 17 of written statement of the state government stated that the answering defendant would like to state that, as stated at the above paras, the suit and the land bearing periodic pata number 1 of 1977, which was converted from periodic pata number 191 of 1974 and subsequently converted into LSC number 103 of 1985, is hereby mutated in favor of F. Bialzawa. Thus, it is humbly prayed that this instance would be dismissed by upholding government letter dated 24/11/2015 for the interest of justice. In the meantime, the true witnesses of the state government also supported the written statement filed by them and reiterated the same in their examination in chief at para 2 and 4 respect of the written statement, and the evidences of the true witness statement are corroborated to each other to prove the genuineness of the impugned order dated 24/11/2005 by cancelling permit number 191 of 1974, and there is no more existence of permit number 191 of 1974. F. The LSC 103 of 1985 of Bialzawa itself clearly reveals.
We'll break here
Yes, my lord.
because it's 1 o'clock. We will continue at 2 from F.
Okay. Type. been
Yes, please read. How
has
many
been
points do you
acquired for the
have?
purpose of office complex of Project Puspak BRTF by the ward number 9 of 1989 and already compensated. H. The name of owner of LSC 103 of 1985
This you
Street.
have mentioned, no?
Oh, I already mentioned, yes.
Ah.
48 of the award. The respondent plaintiff enclosed a copy of permit number 191 of 1974 and marked as Annexure 1 in the plain, which covered 2 bigas only. That is at page 18. In the boundary description of the said permit number 191 of 1974, it could be seen that from the west.
Page 18. Okay.
Page 18. West is the first one. From the west, BRT Lak Sina Ngil Takatan Pain. North, Zoram Moya Ria Chukin Lam Lian Hui Amana Sutatrangin Lam Lian Hui Zela El Road Fin Natlengin is Lalram Liana in Karchin Zel South El Road Dung Zela. Here from the east, BRTF Lak Sinangil Takarin Pain is clearly stated the boundary that it is adjacent to the BRTF land, my lord.
Yes.
From the boundary in the west clearly stated that the land of permit number 191 of 1974 was not occupied by BRTO, but it was located BRTF Ramlak China Ngil Takatan Pain.
For the west, isn't it? Huh?
Yes.
Yes.
The permit number 191 of 1974 was located adjacent to the BRTF land only, adjacent only. J. The respondent number 1 plaintiff enclosed verification report on the claim of compensation by individual on the land proposed to be acquired for Puspak BRTF Zemabog. In there, here I already mentioned, my lord, that block G.
Yes.
I reiterated all those points, or same point. Para 6, the Land Trial Court wrongly decided issue 15 that whether the defendant number 6 and 7 occupy permit number 191 of 1974 without inquiring the same. And para 16, whether the defendant number 6 and 7 are liable to pay rental compensation to the plaintiff. And para 17, that whether the defendant number 6 and 7 should hand over vacant and peaceful possession of permit 9 permit number 191 of 1974 is the same
This
or
para 17, is it issue or para?
yes, 5 para 15, 16 and 17 kept together.
Okay. Decided issue number 15.
15, 16 and 17.
So not para, is it?
Yes, my lord.
Para 16 should be issue, isn't it? Or
Para
at
six-
para 16. What is this?
Para 6,
Decided issue number 15 that whether so and so without inquiring the same, and
16 and 17.
16 and 17 is what, para or issue?
Issue. My lord, some mistake is there. In
No, so this should be read as
Okay, I'm
issue,
sorry.
isn't it? It doesn't make much sense.
Oh, issue number 16 and 17.
Okay.
And para 18. Because it can be clapped together, because whether they entitled or not, whether they occupy the land or not.
And issue 18, not para 18, isn't it?
Yes, issue 18.
Okay.
The respondent number 1 plaintiff never stated anywhere in her plain the time and the manner in which the land of the plaintiff has been occupied by BRTF. They just stated that we are not yet taken back the position, but they never ever stated in their plain in the examination in chief and cross-examination the manner in which their land has been occupied by BRTF. They never ever stated. However, at para 10 of her plain stated that the defendant number 1 had hired, that is typing mistake, hire, HIRE, the plaintiff to take back possession of his land, for which purpose power of attorney dated 19/3/2002 executed by defendant number 1. In the meantime, all the 4 witnesses of the plaintiff had not stated in their deposition before the court when the BRTF occupied the land of Saithang Pui Silo, and never stated the manner in which the land of Saithang Pui Silo has been occupied by BRTF. In the meantime, the witnesses of the party in the case also have no knowledge the time of occupation of the land in question by BRTF and the manner in which the land in question has been occupied by BRTF. At 34 of the plains, Srimati Saithang Pui Silo, she just stated that the action of defendant number 6 and 7, Union of India, in occupation of the land of the plaintiff without acquiring the land and without paying rental compensation is illegal. However, the Srimati Saithang Pui Silo never proved that her claimant has been occupied by BRTF. B. In the meantime, Union of India clearly stated at para 4 of written statement before the Learned Trial Court that BRTF has been occupying the land in question since 1963 and later on Departmental Pass number 4 of 1970 and was issued to them. Accordingly, formal land acquisition proceeding has been done through the state government via Award number 9 of 1989, and no additional land has been occupied by BRTF beyond the state acquisition. As such, BRTF has no more existing liability to pay rental compensation through Srimati Saithang Pui Silo and Thanzawa. C. The state government also clearly stated the reason why there is no more existence of permit number 191 of 1974 in order dated 24/11/2015. Written statement and examination in chief of the two witnesses are corroborated to each other to prove the order dated 24/11/2015 by cancelling permit number 191 of 1974 is genuine and issued legally. D. The respondent number 1 plaintiff stated and admitted at para 2 of her plaint that permit number 682 of 1963 subsequently bifurcated, there is also mistake, into two Viz. Permit number 190 of 1974 and permit number 191 of 1974 respectively. Well, there is no dispute as regard to the right title over the land covered by permit number 190 of 1974. However, at para 31 of the plain, that is at page, in this column, last column, there is a page number. However, at para 31 of the plain, she trying to change her stand taken at the said para 2 by stating that as to how permit number 190 of 1974 was returned to the defendant number 1 as no compensation has been paid and permit number 191 of 1974 has been occupied by defendant number 7 Union of India as block 3, though the said permit was not included, which was not block 3, though the said permit was not included, which was contradictory statement and the same could not be trustworthy from the eye of law. E. The plaintiff along with her witnesses have not adduced evidence before the court to prove that the land in question has been occupied by BRTF. There is no any evidence. F. In the meantime, Union of India stated in their written statement at para 4 A to Z clearly stated that the land in question has been occupied by them properly. G. At para 4G stated that 38.2 acres of land at Zemapok for Project Puspak have been already allotted in principle by Government of Mizoram, Revenue, Excise and Taxation Department, via letter number dated 4 December 1982. Out of 38.2 acres of the land, 29.6 acres are government land and 8.6 acres is private land. In the meantime, the written statement of Union of India has been supported by deposition of their two witnesses before the court, and the same has been corroborated to each other to prove that BRTF occupied the land in question as per law. Whereas the plaintiff, along with their witnesses, never rebut the statement of Union of India anywhere in their evidence. However, she is simply trying to state that her land has been occupied by BRTF without showing any proof for the same. H. Para 16 of Memorandum of Appeal of Union of India stated that even though spot verification has been conducted by this court order, no fruitful outcomes have been arrived at all. However, the Learned Trial Court reproduced some of the statements made by surveyor who conduct spot verification without definite finding of the spot verification. The respondent number 1, plaintiff, as well as respondent number 2, defendant number 1, never challenged Award number 8 of 1989, based on which the Union of India occupied the land in question legally. However, without analyzing the evidence and deposition of witnesses along with available document in record, the Land Trial Court decided issue number 15 to 18 in favor of respondent number 1, plaintiff, as well as respondent number 2, defendant number 1, showing each biasness and the same are perverse and not based on evidence on record at all. Therefore, the impugned judgment and order dated 17/5 2013 in CS 59 of 2016 is liable to be set aside. My Lord, with regards to spot verification, I may be rely upon my Memorandum of Appeal, para 16.
That's
At page 961.
961, what you've just mentioned, huh?
Yeah, because I elaborated the reason why the cross-examination and it's very long.
961.
If I may read para 16 of my Memorandum of Appeal, page number 961. This should be my last submission, my lord.
Yes. Para 16 of
Yes,
your-
my lord. For that, the Learned Trial Court failed to appreciate the spot verification submitted by the Deputy Director for Director, the Land Revenue and Settlement Department, Aizawl, Mizoram, through Srimati so-and-so, the duty report of Sri KLL Chanpuya Surveyor, who was details for conducting spot verification of the land in question, has been submitted before the court by Deputy Director for Director Land Revenue and Settlement Department, Aizawl, Mizoram, through Srimati Grace Lal Swantiki. In his duty report at para 4, he stated that permit number 191 of 1974 he tuna BRTF in block Chiatana and Manhi aninge ni inalang atsan lewang chu anwayami yang hian hantar langila BRTF map atanga alandanin permit number 191 of 1974 he Sorkar Ram Anlak ang inalanga. The spot verification reveals that the alleged permit number 191 of 1974 location had already been acquired by the BRTF by the Award number 9 of 1989. The said survey was cross-examined by counsel for defendant number 6 and 7. He deposed his cross-examination in chief at para 9 that it is also a fact that as per the Annex 1 of the plan, the boundary of permit number 191 of 1974 is in the west, is written as BRTF Lak Chinangil Takatan Pain, and para 10 that it is a fact that since the area of land in dispute has been changed with time, I admitted that the suggestion put to me, the boundary of the permit number 191 of 1974 and the boundary mentioned in my spot verification could not be same in the website. And para 11, that it is a fact that I do not know the exact boundary of permit number 191 of 1974. And para 12, it is also a fact that I do not know the exact boundary of permit number 191 of 1974. And para 13, it is a fact that I do not know as to whether permit number 191 of 1974 has been acquired by BRTF Vital Lot number 9 of 1989 as government free land. And para 14, it is a fact that as per my spot verification report para A, clause A, it is found that BRTF Mepachanga Alandanin, permit number 191 of 1974 hi Sorkaram Anlak ang inalanga. And para 15, it is a fact that I do not have knowledge about Annexure 3 of the written statement of defendant number 6 and 7.
It's
Even
Annexure 3 or Annexure 13?
yes, Annexure 3.
3, not 13.
Yes, our Union of India written statement, my lord, this one is.
So must be 13, not 3, no?
Annexure, oh, my lord, I'm sorry. Oh,
Okay, yes.
13. Then government free land said issued by Under Secretary of the Government of Mizoram Revenue Department. In para 16, that it is a fact that I do not have knowledge about the BRTF has been acquiring the land at Zemabo in the year 1989. This one also mistake, including
85, huh?
89, including 30 acres of government free land. And para 17, that it is a fact that I do not know as to whether the reissue land passed regarding the present permit number 191 of 1974 covered by 29.48 bigas or not. And 20, it is a fact that I do not know the exact area covered by LSC number 103 of 1985 for Pubialzawa. And para 21, that it is also a fact that at the time of spot verification, I do not take a measurement of LSC number 103 of 1985 of PF Bialzawa. And para 22, that it is also a fact that I do not know the exact area covered by the land of Dilalin Kluanga. In para 24, it is a fact that I do not have a knowledge the reason of increasing the petitioner land pass permit number 191 of 1974 from 2 bigas to 29.48 bigas. At para 25, it is a fact that I do not know as to whether the enhancement of the said petitioner land has been occurred due to the fault of Revenue Department. Here my point, even though spot verification has been...
Bigas and 29 bigas, lots of difference.
Yeah,
One
much
will be one
difference.
whole hill lot.
Yes, my lord.
2 bigas is not so.
There is no space for that in that area, my
It will
lord.
be a huge.
Yeah,
it will
very
be
huge. Even 1 acre is also very huge. 29.48 bigas, so be very, very huge.
Is it not?
Here, my lord, even though spot verification has been conducted by honorable court order, however, no fruitful outcomes has been arrived at all. As to whether alleged permit number 191 of 1974, which was increasing from the area 2 bigas to 29.48 bigas, void of his letter dated so-and-so dated 11/10/2003, issued by Deputy Secretary to Government of Mizoram Revenue Department, is within the acquired area of BRTF at Block 3 or not. The enhancement of the said area covered by permit number 191 of 1974 had already been cancelled by the state by letter so-and-so dated 24/11/2015, issued by the State of Mizoram, then Revenue and Settlement Department, Aizol, by clearly explaining the reason why therein. As such, the claim of ownership in respect of permit number 191 of 1974 is void binto. The Land Trial Court did not entertain the spot verification report along with cross-examination of the surveyor who conducts spot verification. the land trial court never compared with the boundary description of permit number 191 of 1974 enclosed by the plaintiff as well as the defendant number 1 with the finding of spot verification. In the meantime, the boundary description of permit number 191 of 1974 and verification report are not corroborated to each other. Hence, the impugned judgment and order dated 17/5/2003 is liable to be set aside in quas. Then, my lord, one more point. In order to ascertain the whole area of the original pass, that is permit number 682 of 1967, we wrote letter to the Revenue Department, that is at page 582.
The original, this thing,
Yes.
pass was numbered. Just repeat.
Permit number 682 of 1963.
2 of 1963.
That is
okay.
Lian Tudaya, fathers of the
The
Tanzama.
origin was this.
They
isn't it?
forget it into two parts. Then
Page 582.
582, my lord. We request the Director of Land Revenue and Settlement Department to provide us the original permit number 682 of 1963 to ascertain how much area has been covered by the original one.
And what is this thing? Any response to that?
Yes, my lord. At page 584. Referring to your letter number and subject cited about, I would like to inform you that since the permit number 682 of 1963 was issued by then the Mizo District Council record of the same is not available with us.
So,
As such,
throws no light on the area, isn't it? So we don't know.
as such, a copy of the same could not be provided. That's all, my lord. Yeah,
they cannot verify.
that is why, yes, I pray that the judgment and order passed in CS 59 of 2016 may be liable to be dismissed, liable to be set aside in cause, my lord, for the ends of justice. That's much obliged.
Yes.
Your Lordship, state is rate as respondent number 3 and 4. No, 3 and 4.
So you're for respondent number?
3 and 4, yes. I'm representing respondent number 1.
1.
Um,
Who was the plaintiff
a plaintiff, yes.
in the civil suit? Okay.
Much has been said about the case, but Your Lordship, I'd like to make certain statement, the brief facts of the plaintiff case. And the manner in which the matter was undertaken by the state government. And at this stage, though the state government has been rated as respondent number 3 and 4, it appears that since the state has not filed an appeal in respect of the first judgment which was passed in connection with the said suit, 59 no, 59 of 2016. And since they have not filed their appeal even against the judgment passed in the subsequent suit, I think it will be just.
So they are the respondents.
They
here
are
in the
respondents, though they're
sentencing suit.
respondents, but I feel that they have nothing much to say.
Oh.
Nothing much to say. And they have complied with whatever direction that has been passed by the trial court in connection with this, the said case. And I don't know whether the learned government advocate should be first allowed to make a submission as to whether they have anything at all to say. If they have.
We only have submission that this dispute is between the PRTF and respondent number 1 and 2. And the other respondent is with regard to issues of land parcels.
So whatever your submission is as on record, nothing. The records available because you have made some observations in your verification report. And one of your, this thing, orders was challenged, is the one which is under challenge, isn't it? The verification report, which is under challenge by the respondents. The respondents, the appellant is relying on your verification report, isn't it?
It's
So
not
you-
a verification report.
some finding, whatever.
finding.
That order made by
cancellation of its earlier
Cancellation, yes.
decision.
and the demarcation of the land mutation. They're all relying on that. The appellant is relying on that. So you have nothing to say regarding that. That's your document.
Your Lordship, for the purpose of streamlining the argument on behalf of the respondent number 1, I have prepared the synopsis of argument,
Yes.
and that will be simply as a guide.
Okay. Yes.
And under the brief facts of the plaintiff's case, under A, I've stated that permit number 682 of 1963 was issued to Sri Liantudaya, late father of defendant number 1, and the same was subsequently bifurcated in 2 permits, such as permit number 190 of 1974 and 191 of 1974, both in the name of Sri Liantudaya, who died on 20/2/1986, while the land covered by permit number 190 of 1974 was earlier released to the landowner, and the land covered by permit number 191/74 continued to remain with the appellants till date, and this is the subject matter of the instant dispute. And in this connection, if I take Lordship to Exhibit P1, page 18, which is also Exhibit P2, page 301, in connection with the recast plain. Lordship, both the documents have been annexed in both the planes. The first plane, the original plane, as well as in the recast plane. Page
Airship, sir. The page 19 is the airship, sir. Page 18. This was
18.
also exhibited by the
Yes.
IS
This
regarding the
is
border.
permit 191 of 1974, which has been retained by the BRTF till date, the appellants.
Concerning this, she had mentioned the west side, BRTF, the western border.
Yes, under the occupation of the BRTF till date. And Your Lordship, permit number 190 of 74 was released to the landowner, that is Sri Tanzava, on 7/12/2001. May I take a lordship to page 548, Exhibit D22.
Five, four, eight.
548. (548) is a receipt in which it was stated that land against permit number 190/74 as included under plot number 45 of block 2 of HQCEP Puspak area at Zembok has been taken over by me on 7th day of December 2001. So it has been taken over by Sri H. Tanzava because it was, though initially covered by the acquisition, what was made. What number?
Okay, that mentioned award, is it? Where they
Award.
were shown at serial 48.
Yes. At page 44, a lordship will see that there was the award 9 of 1989.
Oh.
In that, the name of Tanzava Liantudaya was there.
Page 44.
44, starting from 44. At page 48, serial number 49. 48 and 49. 49.
48 is Bialzawa.
Yes. 49 is Liantudaya. Liantudaya is the late father of defendant. number
So
2.
190 is not disputed anyways, is it?
190 is not disputed.
Huh.
So it has been restored to the owner, Tanzawa. It's Tanzawa has taken it back on
Tanzawa or Bialzawa?
7th day of December 2001.
Tanzawa.
is
Then
the-
on top, serial number 48, Bialzawa. Is this the same as Tanzawa or
No,
someone else?
Bialzawa is the one who had purchased a portion
Okay,
of the land
okay.
covered by
Uh-huh.
191.
Okay, so Bialzawa and Tanzawa are different people.
Yes.
Hmm.
And Your Lordship, heirship certificate was issued declaring the defendant number 1 as the legal heir of late Liantudaya, the deceased, in respect of all the properties left by him. White heirship certificate dated 14/3/2000, Exhibit 2, page 19. Your Lordship, incidentally, it was an heirship certificate which was issued by a Lordship sitting as a magistrate first class, sub-district council court, way back in 2000. And this is in respect of all the
But
properties.
This is general, very general, all the properties. Luckily, no property has been mentioned. Good. Otherwise, the dispute, because I think the property, something is there. All the properties left by him,
And yes, this also has been exhibited as Exhibit P3 in the recast plate at page 302. On 12/4/2002, there was in rem Nathuthung, which was signed between the plaintiff and defendant number 1, in respect of the land above the Aizol Lunglei Road, outside the BRTF fencing covered by permit number 191/1974 for a sum of rupees 20,000. Exhibit P3, page 2021. There was an agreement.
but now the contention
Which
is
has-
this
which has
permit
nothing to do
number
with the case now.
191.
It is simply a history.
Okay.
There was an agreement between the plaintiff and the defendant number 1, who are the respondents number 1 and 2, in respect of the land above the Aizawl Lunglei Road, outside the BRTF fencing, covered by permit number 191, 1974. And thereafter, on 6/6/2002, an application was submitted by the defendant number 1, that is the respondent number 2 now, to the Chief Secretary for proper measurement of the area of permit number 191/74 and to issue pass afresh as per the boundary description. Lordship may turn to page 4 of the first book. There are 2 books. Page 4, Exhibit P4, page 22 to 24. We are including the English translation. And which is also exhibited as Exhibit P5 at page 305 to 307 in the recast plain. And the area of permit number 191 of 1974, recorded as 2 bighas, on remeasurement was found to be 29.4 bighas. However, on the basis of Office Memorandum number so-and-so, dated 26/8/1991, it was decided that only the area allotted as shown in the original paper be allowed for conversion into permanent settlement, even if the boundary description covers the area. The area of permit number 191/1974 was retained as 2 bighas in spite of the correct area as per remeasurement, white letter dated 10/5/2002, Exhibit P5 at page 25. This is the view taken by the state government. And this is also exhibited as Exhibit P6 at page 321, 322, the same document. As per verification report dated 11/9/1989, on claims of compensation in connection with the land proposed to be acquired for Puspak, only the name of Pu Bialzava was shown as the claimant under Block 3. As per available record, Sri Lian Tudaya had sold his land covered by permit number 191/1974 with an area of 2 bighas to Sri Bialzava on 10/6/1977. Thus, the remaining portion, that is 29.48 bighas less 2 bighas, was not shown under Block 3. Lordship may turn to page 35 of the paper book. At the bottom of the page, there is Block 3. It states, there is only one claimant of compensation within Block 3, namely Pu F. Bialzava. There is no land dispute within Block 3. So this is what has been recorded during the course of acquisition in connection with award number 9 of 1989. As per verification reports, then thereafter the claim of the defendant number 1, as stated via his letter dated 24/6/2002, Exhibit P6 at page 40 to 41, which is also shown at Exhibit P7, page 323, 324 in the recast plain, was that his late father had sold only a portion, that is 16,765 square feet of his land covered by permit number 191/1974 to Sri F. Bialzava in the year 1979, and the remaining portion of land was not sold to him. 3 F. Bielzava was issued P. Pata number 1 of 1977, which was later converted to LSC number SZL 103 of 1985, with an area of 2,622.49 square meter, oblique 28,217.99 square feet, oblique 195 biga by the Revenue Department. Which I have stated at Exhibit P6. The fact that I have sold, my late father had sold only a portion of his land, and the portion sold by his late father is only with an area of
Sold it
2622.49
to this, the present, sold it to whom?
to Bielzava.
The present respondent number 1, isn't it?
No, Bielzava is the one who had purchased 191, some portion of 191.
Okay.
He's not a party here.
Okay, it's not a party. Then who's the other one? Samzava? Not Bielzava. Then
Tanzava is
Tanzava. Okay,
Tanzava
I'm getting
is-
confused.
respondent number 2.
Hmm.
Is the defendant number 1
Okay,
in the
yes.
suit. White Award number 9 of 1989. The land of Sri F. Bielzava with an area of 16,765 square feet, covered by LSC number 103 oblique 1985, was acquired for the purpose of office complex of BRTF at the rate of rupees 30 per square feet. This can be seen at Exhibit P8. The manner in which it was acquired. Award number 9 of 1989. And the name of the LSC of Sri Bielzava is shown at serial number 26,
Page 44. isn't
page
it?
48, 45. At page 45. And 48. And 48 also at page
No, page 45, serial number 26. Is it?
26. His name was not shown, but
No,
his
name is
LSC was
not
shown. And at page 48, at serial number 48, his name and his LSC number and the valuation of his land was shown at serial number 48.
48 and 26. LSC is the same.
Yes.
So why is it shown? Okay, the following persons have filed their claims. So if it's shown in one place, it's okay. Page 48, they have filed their claims. Same LSC. Here land valuation is 30 per square feet, but the area is not shown here, isn't it?
Area is shown at page 45,
So area is supposed to be
16765.
16765.
Yes.
Okay.
This is only 1.95 biga.
16765. 1.9 bigas.
1.95 biga.
Well, you're saying that it is 2 bigas.
9.5 is more or less 2 bigas.
2 bigas, huh?
Yes. And White Award number 9 of 1989, the land of Sri Bielzava was acquired for the purpose of office complex, and White letter dated 10/10/2002. I'm at point H. Defendant number 1 was allowed conversion of the land covered by permit number 191 of 1974 of 2 bighas for house site, as per Exhibit P10 at page 55.
But this 105/2025 comes out of 191 of 1974, isn't it?
191 of 1974, yes.
So if 103/1985 has been acquired, then the submission made by the counsel for the appellant was 103/103/1985 is the same as 191 of 1974. Same landed area. That's what she's
it is
saying.
a part of 191 of 74, not the entire area of 191.
Okay, so
of
103 is 2 bighas.
Yes.
Okay.
103.
But 191 is also 2 bighas. So altogether 4 bighas or what? What's the meaning of this?
No, Your Lordship, there was a proper measurement of the area as per the boundary description, which will come to later.
Okay. So 103 is 2 bighas, and out of that, he was again allowed to convert 191 into what?
House pass.
Okay.
And as per letter dated 14/10/2003, which is at Exhibit P12,
P12
page
is page
57.
57.
At page 57, there is a letter which said, which was addressed to Mr. Tanzawa. Addressed to Mr. Tanzawa, respondent number 2. On the subject area covered by permit number 191/74 regarding, I am directed to state that the exact area covered by permit number 191/74 as per spot demarcation according to the boundary description done by the joint team consisting of Sri Sandeep Gupta, AEE C 107 RCC, Sri Lal Machuana, ASO2, and Sri Lal Ringlianaton Singh, Survey of 1, on 24/3/2003 is 29.4 bighas instead of 2 bighas. This was a letter from Deputy Secretary to Government of Mizoram Revenue Department, addressed to Tanzawa. Respondent number
So
2.
is this correct?
This
It's
is
huge.
the finding of the government.
But you went to the land, you must be knowing your land. Can it be
Yes,
29
yes.
point? It's
Yes,
very huge.
Your Lordship, it is correct.
Because previously you had prayed only for conversion of 2 bighas.
What we have sought for is conversion of the land covered by 191 of 74 to house site. And
But house
it
site,
was recorded
2
as 2
bighas.
bighas. It was recorded as 2 bighas.
But you must
I
be
cannot,
knowing
I
your
cannot
land.
simply change
Uh,
because after that I had sought for an application for remeasurement of the area.
okay.
I had sought for remeasurement of the area. And accordingly, on redemarcation and remeasurement, the entire area, including the land which was earlier taken over, permit number 191 of 74. In fact, Your Lordship, it may be clarified that what I had sought for earlier for house site pass was outside the BRTF fencing. This is within the fencing.
So it's saying this 29 bighas is 191, which is inclusive of 103.
103,
Is it?
yes. As per verification report dated 11/9/1989, which is at page 58. Has the lawsuit got it? 58.
Yes.
May I read the joint spot verification report? As per order number, it's been so-and-so dated 12/3/2003. The land covered by Block 3 of the BRTF acquired area located at Zembok was visited by joint team of Directorate of Land Revenue and Settlement, IZOL, and 24th BRTF on 24/3/2003 at 11:30 a.m. After a short discussion, we came to a conclusion that the area of the said Block 3, which had already been demarcated long time back, need no fresh demarcation. According to the earlier demarcation, which was already approved, the area of Block 3 is 29.48 bigas. This area is not questioned by any party till today. The site visit was done in the presence of concerned VCP and the applicants, and nobody has put forward any objection. In that, the representative of the BRTF 107 RCC, Gref, Mr. Sandeep Gupta, AEE Civil, was also present, and he put his signature in the joint spot verification report. So this is a very important piece of document certifying that the area which has been under the occupation of the BRTF, the appellants, which is covered by permit number 191 of 1974, was 29.48 bigas. Lordship, may I come to next? The claim of defendant number 1, as stated, provide his letter number.
You're reading from?
And thereafter, Lordship, at page 59, Exhibit P14, permit number 191 of 1974 was issued afresh on the basis of the findings of the joint verification team. This permit number 191 of 1974 was issued afresh by the Revenue Department. In that, the name of Sri Liantudaya was shown as the owner. It is under Section 3 of Mizoram Agricultural Land 1960, Land Act 1960. The land prescribed hereunder is allotted and permit granted on the following conditions. And the area is at serial number 2, area in bigas, 29.48 bigas. So this is at Exhibit P14.
Okay.
And the claim of defendant number 1 as stated, write his letter dated 24/6/2002, Exhibit P6.
Yes, you're
Yes, Your
reading
Lordship.
from?
May I take Your Lordship to exhibit the point H. White letter dated 10/10/2002. The defendant number 1 was allowed conversion of the land covered by permit number 191 of 1974 of 2 bigas for house site. Exhibit P10 is at page 55. And thereafter, remeasurement was made and the finding of the team has also been stated. It was clarified and confirmed by the Deputy Secretary, Government of Mizoram, Revenue Department, that the area covered by permit number 191 of 1974, as per spot demarcation according to the boundary description done by the joint team consisting of Sandeep Gupta, AE C107 RCC and others on 24/3/2003 was 29.48 bigas instead of 2 bigas. Thereafter, at serial number I, White Sale Deed dated 19/11/2013, which was duly stamped and registered under the Indian Registration Act 1908 on 25/2/2014. The defendant number 1 sold the land covered by permit number 191 of 1974 with an area of 19.82 bigas for a sum of rupees 30 lakhs to the plaintiff. This is Exhibit P19 at page 70. Over here,
Page 353, is it?
353
Or page
in-
70?
Yes.
Okay, there's also in page 70, the first one.
in the recast plaint. It is also there. Though the validity or genuineness of Exhibit P19 was questioned by defendant number 1, it was found that the same was genuine as per the report of FSL, White Exhibit P27, page 108 to 116. And it's also shown at Exhibit P28, page 390, 399 in the recast plaint. Lordship, there is no longer any dispute between the defendant number 1 and the plaintiff at this point of time. And this is one point which has been strenuously stressed upon by the learned CGC as regards whether
But she had pointed out the difference in the written statement and the cross-examination.
yes, that
Contradiction in that.
will explain. And at point J, though the defendant number 1 had taken the stand that he did not execute Exhibit P19, however, at the time of his cross-examination during course of proceeding of the suit, that is civil suit number 59 of 2016, defendant number 1 had admitted the fact that he had sold half portion of his land covered by permit number 191 of 1974 to the plaintiff, as clearly indicated in his cross-examination at page 226 to 228. Consequently, the plaintiff, having accepted the version of defendant number 1, that instead of 19.82 bigas, he had purchased only half portion of the entire area, the dispute between the plaintiff and defendant number 1 was resolved between them even before the judgment and order dated 5/4/2019 was passed. This 5/4/2019 was the original judgment, Your Lordship. Even before that judgment was passed, both the plaintiff and the defendant number 1, who are the respondents number 1 and 2 now, they had made a mutual agreement outside court, and on that basis, they have come to a settlement as regards how much of his land has been purchased by the plaintiff and how much is retained by the defendant number 1. So, however, defendant number 2 and 3, that is the state respondents, at point K, they had taken the stand that after Sri Liantudaya, late father of defendant number 1, sold his land under permit number 191 of 1974 to F. Bielzava, the entire area thereunder was conveyed in favor of F. Bielzava. That government of Mizoram, without knowing the full facts, had conveyed approval for conversion of permit number 191/1974 into house site, with 2 bigas and later corrected the area to 29.48 bigas on 15/11/2003. So this was the subsequent stand of the government, that is respondents number 4 and 5, who were the defendants number 2 and 3 in the original suit. They had taken the stand that permit number 191 was entirely eaten up by the land which was sold to Mr. F. Bielzava. And they had taken the stand that without knowing the full facts, they had conveyed approval for conversion of permit number 191/1974 into house site with 2 bigas and later corrected the area to 29.48 bigas on 5/11/2003. Accordingly, in view of Land Revenue Acts and rules, the claim of Pu H. Thanzava, defendant number 1, was treated as a closed chapter as conveyed White Order Memo number and so dated 24/11/2015, which is at Exhibit P33.
Page 133.
Page 133. To 135.
This was also read out by the counsel for the
Yes,
appellant.
this is the main grievance of the plaintiff in connection with the suit. And this was the stumbling block. And this was challenged by the plaintiff.
So no longer existed 191, isn't it? Here in the order, 191 no longer exists
Yes,
because it was already converted.
permit number 191 of 1974 was then converted to Pipata number 1 of 1977 with area of 2 bigas. But this is the view of the government. When Pu Thanzava, at serial number 5, para number 5, when Pu Thanzava, son of Lian Tudaya, prayed to the Chief Secretary on 6/6/2002 for redemarcation of permit number 191 of 74 on the plea that he was outstationed at Saitwal, it appears that he had no knowledge that his father Lian Tudaya had already sold this permit number 191/74 to Bielzava way back in 1977. The government, without knowing the full facts, had conveyed approval for conversion of permit number 191/74 into house site with 2 bigas and later corrected the area to 29.48 bigas on 5/11/2003. They're narrating the history, how it has developed. That is long after permit number 191 of 74 was already mutated into LSC number 103 of 1985 in favor of Pu F. Bielzava. This was, however, clarified under White letter number so and so dated 10/5/2002. Should I read the whole thing, Your Lordship?
No, not really. So this was read out.
This
isn't it? This whole
stand-
thing was read out.
Yes,
This
this
was in favor of the appellant, huh?
This is in favor of the appellant, and the appellants have been stressing that this should be the stand of the government. They should take up this matter by filing an appeal even before the appellate court if the government is aggrieved. But government is not aggrieved by the decision of the trial courts.
In spite of making this order.
Yes.
Before, huh? Okay.
May I take Lordship to the learned trial court by its judgment and order dated 5/4/2019.
You're reading
While
from where now?
I'm reading from middle of J.
J.
Page 4, yes. The London Trial Court void its judgment and order dated 5/4/2019 while deciding issue number 14 thereof had decided that the order dated 24/11/2015 was illegal, null and void. Consequently, the same was set aside and quashed and permit number 191 of 1974 reissued on 17/11/2003 with the approval of the government was revived. May I take Lordship to page 271 to 274. This is where they have decided the issue number 14. This is part of the judgment. Number of issues have been framed and decided, and this particular issue, which is issue number 14, is whether the order dated 24/11/2005 cancelling permit number 191 of 74 is illegal, null and void or not. So this is the moot question that needs to be decided. And the London Trial Court had decided the issue in this manner. This issue has to be decided by looking into the chain of events leading to the passing of Order 24/11/2005 by the respondent number 2, as well as the oral and documentary evidence submitted before this court. It can be seen from the records that the plaintiff number 1 had instituted WPC number 48 of 2015, wherein she had prayed for inter alia to consider the representation dated 27/5/2014 for implementation approval for cancellation of LSC number so and so as held in the meeting minutes dated 21/7/2010 and to allow partition and conversion of her landed property into 10 LSCs. The said writ petition is disposed of at the motion stage, white order dated 1/5/2015, with a direction that the Principal Secretary, Land Revenue and Settlement Department, Government of Mizoram, shall dispose of the said representation of the petitioner dated 27/5/2014 on or before 31st August 2015, with a speaking order, subject to the condition that the petitioner shall submit certified copy of the order along with a copy of this petition and all the annexes appended thereto before the said Principal Secretary, Land Revenue and Settlement Department on or before 8/5/2015. Accordingly, a certified copy of order dated 1/5/2015 along with writ petition with its enclosures was served to the Principal Secretary, Land Revenue and Settlement Department. Here, Lordship, however, the said Principal Secretary, Land Revenue and Settlement Department had failed to comply with the said order of the Honorable Guwahati High Court Aizawl Bench, and a contempt case C number 16 of 2015 was instituted against him for his failure to implement the order of the Honorable Guwahati High Court Aizawl. During the pendency of the said contempt case, defendant number 2, who is a contemptor, had passed an order, memo number so and so, wherein defendant number 2 had decided that permit number 191 of 1974 was no longer in existence in 2002, thereby cancelling permit number 191/1974, which was inherited by the defendant number 1 from his late father. The arguments of the parties in this regard are as below. Counsel for the plaintiff submitted that permit number 191 of 74 was very much in existence in 2002, as the same has been reissued to the late father of defendant number 1 on 17/11/2003 after it received government approval, white letter dated 5/11/2003. Therefore, cancelling the said permit number 191 of 1974 without giving an opportunity of being heard to the landowners cannot be allowed to stand the scrutiny of law and is against the principles of natural justice. In fact, the contents of the plaintiff number 1 in
So
the
this
PPC
cancellation was that order which you read by the state government, isn't it?
Yes.
Oh, okay.
against the principle of, in fact, the contention of the plaintiff number 1 in WPC number 48 of 2015 is only with regard to the land lying outside the fencing of the BRTF and not the whole area of the permit number 191 of 74. Therefore, action of defendant number 2 in passing the order dated 24/11/2015 on the basis of contempt case instituted against him without applying his mind is illegal, arbitrary, and the said order dated 24/11/2015 is liable to be set aside and quashed. Counsel for defendant number 1 also argued in line with the submission of the counsel for the plaintiffs and submitted that show cause notice was not served to the defendant number 1 and that he is not aware of the writ petition or the contempt petition filed by the plaintiff number 1 at the relevant point of time. Therefore, his permit number 19174, which he had inherited from his father, cannot be cancelled by respondents without affording him any chance to explain himself, and therefore submitted that the order dated 24/11/2015 needs to be cancelled, as the same is in violation of principles of natural justice. Government advocate submitted that there is nothing wrong with the order dated 24/11/2015, and the same has been done as per law, and praised that the order dated 24/11/2015 may be upheld by this court. In view of the submissions of the parties and on perusal of materials available on record, it can be established that the defendant number 2 had carelessly passed the order dated 24/11/2015, holding that permit number 191/74 was no longer in existence, thereby implicating that permit number 191 of 1974 reissued to the late father of defendant number 1 was cancelled. The records and evidence adduced before the court also reveals that defendant number 1 or the plaintiffs were not given any chance to be heard before cancellation order dated 24/11/2015 was passed by defendant number 2. In fact, a perusal of the records also reveals that the only claim made by the plaintiff number 1 in WPC number 48/2015 was with regard to the portion of land lying outside BRTF fencing and not the whole area covered by permit number 191/74. Therefore, cancellation of permit number 191/74 without giving any chance to the landowners, void order dated 24/11/2015 by the respondent number 2 on the basis of the said writ petition and the connected contempt case cannot be allowed to stand the scrutiny of law. As such, the order dated number so and so dated 24/11/2015 is declared as illegal, null and void.
Okay,
So
let's
this
come
is-
back to this order. This order that includes the order which you just mentioned, no?
Yes.
It was passed by the revenue in compliance with the judgment and order in the contempt case. Now, WPC 48/2015, that judgment, it was the presence of the parties necessary? What was this thing?
In fact, Your Lordship, what was directed by the court in a contempt case was to dispose of the representation, not on. That there was no further direction other
No,
than
but
to
WPC, what was the order in WPC?
WPC order.
WPC was to this thing with both the parties present. Won't it be that?
Yes.
So when both the parties were present, verification must have been done with both the parties present. Then the contempt, I'm just trying to figure out, I'm not understanding this part. no?
Yes, Your Lordship, I'll try to.
Contempt will be only to comply with WPC 48/2015. So how did this order come up?
May I take Your Lordship to 152, page
152.
152, 155.
Operative quarters.
Lordship,
Okay.
this is a writ petition, 48 of 2015.
Operative quarters. Okay, just to dispose of the representation.
Well,
Both
disposing of the
presence of the parties was not required.
while disposing of the said writ petition, petitioner, dated 27/5/2000, the authorities shall inquire into the matter, verify the relevant and original records of Land Revenue and Settlement Department with regard to allotment and settlement of the land that petitioner purchased, giving the parties an opportunity of hearing,
Okay.
including the petitioner and the person whose LSC is going to be cancelled, if decided. After
Opportunity
disposal
of
of the
being
said
heard.
presentation, authorities shall intimate the outcome of the same to the petitioner. So this was not done for a long time, and thereafter,
After the contempt.
contempt, yes, contempt.
So then the order
case
was
filed.
passed.
Yes.
But the order appears not to be in compliance with WPC 48 because opportunity of being heard was not given.
That's true.
So that contempt shouldn't have been disposed of. They should have said opportunity of being heard was not given. And then this order could have been looked again during the contempt petition only. So how was the contempt petition disposed of? Order
Lordship,
is there?
the manner in which the matter was taken up by the Revenue Department was by reassessing the matter in their own way, and saying that the application of the defendant number 1
Was
that is-
disposed
yes,
of?
it was
with this
disposed
order.
of, saying that it's a closed chapter. There is nothing left when it was already purchased by Mr. It was sold to Mr. F. Bielzava, and there's nothing left.
So no,
So that
whatever,
was what they said.
Yes, whatever the order, this order, they're saying it's in compliance with the WPC.
Yes.
So when the contempt petition was being considered, the petitioners, who are the petitioners, the present respondents, they should have said
Respondent
that they should
number-
have said this is not in compliance with the judgment and order in WPC because they were not being heard. Then the civil suit did not have been filed.
Yes, that was the very reason why the order, which was passed by, the impugn order, which was passed by the secretary,
So why did you
that was
why
dated
did you allow the
24/11/2015.
contempt? So at the time of considering the contempt petition, the contempt petition should not have been disposed of. It should have, this point should have been raised. The state respondents will say we have complied, but you can say that we were not heard, therefore it is not in compliance with the judgment and order, and then this impugned order could have been looked into before the disposal of the contempt petition. Are you getting my point? That was not done.
What ought
That
to
should
be
have
done,
been done at
what
that
ought to be
time.
done was not done. That's true. And in fact,
Then all this wouldn't have happened.
even before the matter was decided, as per the impugned order, which is dated
See, now in the impugned order, you are disputing, yes,
24/11/2015.
you are disputing this impugned order by saying that we were not heard, we were not being
That's
given
true.
opportunity to be heard. So therefore, this impugned order is
That-
not in compliance with WPC.
That is
But the contempt petition was disposed of.
that
It
is
shouldn't have been.
a matter of history now. Your Lordship.
But then I'm
It's
just
a matter of
observing,
history.
shouldn't, we
Yes.
should have protested the
Yes.
petitioners at that time.
It is a matter of history now. What was not done was not done, and
But
the
why
Ghana
didn't you,
trial
why
court
didn't you
had passed
object then?
the order setting aside the impugned order dated 24/11/2015. Now, the matter was disposed of, and it was lying, unappealed. It was not agitated by the state government. Respondents number 3 and 4, they did not agitate. They have accepted the view of the honorable, the learned trial court. And now,
Now trial
Now,
court.
in
But the
connection with the-
contempt, at
yes.
the time of contempt, this shouldn't have happened. I'm just saying. Anyway, sir, then all this won't have cropped up.
Lordship, this order having been passed by the learned trial court at the first instance, in the absence of the appellants. Now the appellants having been informed that this order has been passed in their absence, and the informant is the state, no other than the state respondents. The respondent number 3 and 4. They had conveyed the message to the appellant that if you are aggrieved with this, you may file an appeal. But so far as we are concerned, we are not filing an appeal. This is the message.
So the whole issue cropped up because of the contempt petition being disposed of,
Yes. As a
which is
result,
not in compliance with the WPC.
that may be the root cause.
That is a root
But
cause.
but as of now, what is the situation is that the state government, not being aggrieved, have not filed an appeal against the said order dated.
No, but now my question is, now the question that arises is, now in the contempt petition, they have said that we have complied with the order of the court. The order of the court is that both the parties are to be heard, etc. Okay. When the
That's true.
WPC says in the presence of the parties, if whatever, and now you agree that, okay, now contempt petition has been disposed of, that means it is presumed that both the parties were also considered.
At this stage, Your Lordship,
How can you dispose of the contempt when, because the point you're raising just now, what you just read, no? That they, without their being heard, without
Yes,
giving,
that's
but the WPC says that they should be heard. And in the contempt petition, the state respondents say that we have complied with the judgment and order in WPC so and so. And the petitioner also agrees that, okay, the compliance has been made as per WPC so and so. But now you're coming up saying that it appears that WPC was not complied with because parties were not heard, no notice was given. Disposing of the contempt petition because you agree, WPC.
Your Lordship, this page
That little technical
158
point I'm just
yes,
raising.
Here in contempt case number 16 of
Where's
2015,
the order?
at page 158 to 165,
158.
158 to 165, this is a contempt case. We have not enclosed the order.
How was the order? Were the petitioners present when the contempt case was disposed of?
For purpose of expediting the matter, Lordship,
I'm
this
just
contempt
curious.
case number 16 of 2015 may also be called records. Records may be called for.
Yeah, I think we will call for the records.
What has been done in connection with that contempt case. Because the order has been passed by the authorities concerned, it could be that the contempt case was closed.
They read that the contempt case because, but the petitioner should have been present there, contempt petitioner, saying that, no, this is not in compliance with the WPC because we were not given notice, we were not, they could have objected then. I mean, okay, whatever, a lot of has passed, but I'm just curious, why, what happened then? Anyway, so we'll call for, if it's required, otherwise whatever is done, it's bridge over water actually. Then civil suit has been.
Lordship,
So will that
shall
be
we
a
continue or
important
shall we
point?
wait for the records to come?
Okay, we can do that also. Contempt case, isn't it? If the contempt case has been closed, that means WPC has been complied with, then you were given an opportunity maybe of being heard also at that time. I don't know. The order doesn't mention that. The impugned order of the state government, they don't mention that.
And Lordship, thereafter, the decree was passed at page 277.
Anyways,
All right. The Lordship has any other engagement. All right. Right. We'll continue tomorrow. All right. All right.
next week,
Next week. We'll continue on Monday.
heard Ms. Zaram Sangpui, learned CGC for the appellants, along with Mr. Phil Ramzawa, learned senior counsel for respondent number 1, assisted by Zoram Channa, learned counsel. I think we'll mention, and also heard Mr. L.H. Yanshima. No, we will not mention heard. Okay. Having heard the submissions made by the learned counsels, matter is put heard and to be listed again on Monday's date. So and so. The presence of Mr. L.H. Yanshima, learned counsel for respondent number 2, and Ms. Lalnundui, learned government advocate for respondents number 3 and 4 is noted. Meanwhile, the record of contempt case number, what is the contempt case number? 16 of
16 of 2015. 2016. 2015.
This contempt case number 16 of 2015 is to be tagged along with the instant regular RFA. Okay. Yes.